My lord.
Make a mention a day after tomorrow.
My lord.
I may pardon to make a mention. Yesterday one matter was before my lords that challenged the virus of an engineering act. Your lordship has instructed me to make a mention today, so that matter can be taken up next week. And I have taken consent of senior counsel, Mr. Ashok Mahathi, and also Mr. Vidhara Uttray and Subir Palit. They are ready to argue this matter on 8th or onwards. Your lordship may fix any day after 8th. 8th. I'm giving that number. madam.
I don't want to make a mention, my lord.
Just a minute.
Two matters I have given that yesterday one matter was there and another connected matter, that first matter where we have filed the counter. Two matters I have given that number. Out. And another matter, fresh writ appeal, the contempt is filed.
Contempt?
No, my fresh writ appeal filed by the state. Any day next week.
No, what is the urgency?
Urgency, the contempt is filed.
Contempt is filed.
My lords.
Then when was the order passed?
In fact, order was passed in that writ petition in November 2023.
Give your slippage.
Matter.
And whether contempt matter has been taken up?
On Friday, that matter was last Friday. Matter was,
The matter was taken up.
my lord.
Then
Contempt was notice was issued. So we,
all right, bills. Give us
One restoration application, my lord, CMAPL.
restoration.
Please, your lordship. No, they have not complied the order.
So we have complied the order, lords, and filing the compliance affidavit. Payment has already been made to his account. Everything has been done.
As per my instruction. I will go through.
Also, we look at this statement of the account also.
Yes, this has been done, Mr.
I will go through. My lord, keep it pending.
No, please read paragraph 3.
Yes, my lord. Humbly submitted, that is humbly submitted that in amount of 23 lakhs 26,400 has been submitted to Sub Treasury Balikuda on 30/4/2024 by bill number so and so dated 28/4/2024 and dated 28/4/2024, and the same will be transferred to petitioner Jyotiranjan Rao account.
Treasury has already been advised.
Uh,
Yes, my lord.
compliance affidavit has been filed on behalf of the contemners, stating therein that this court's order dated 22/11/2017 passed in WPC number 5320 of 2014 and subsequent order dated 6/3/2023 passed in contempt CONTC number 1433 of 2018 has been complied with. First off, it has been stated that an amount of rupees 23,26,400 has been submitted to the Sub-Treasury Balikuda on 30/4/2024 and the same shall be transferred to the petitioner's account. Full stop. Considering the aforementioned stand taken in the compliance affidavit, the contempt application stands dropped.
Lordship, liberty may be granted to approach this honorable court again if there is.
Oh, you will not be granted any liberty. If the amount is not deposited in your account within 2 weeks,
Yes.
you just make a mention, we will initiate contempt proceeding then and there. You don't have to do anything, just make a mention, we will see.
Obliged.
No, he says that liberty for if any further amount he is entitled to liberty. My lord.
That's why
It goes without saying that if according to the petitioner, the amount which is the computation of amount payable to the petitioner is not to his satisfaction, comma, he shall have liberty to raise his grievance before appropriate authority.
grateful.
Item number 2.
So item number 2,
I'm appearing with the petitioner, my lord.
I've got instruction, the person he has made a party, he is not the appropriate authority, my lords. It is National Highway Authority of India, and he has made the state National Highway Chief Engineer as purported party. And after receiving your lordship's order, in fact, the present container has written to the Chief Engineer, my lords, and the project director, National Highway Authority to comply the order. So my friend can now amend his, my lords, I'm giving details of the orders part. He has to either amend or, my lords,
No, you withdraw the petition, file
press
another
application.
petition. How can we proceed with this?
My lord. I'll
How
file
can you
this.
proceed with this? The petitioner has alleged disobedience of this court's order dated three to 2022, passed in WPC number 10749 of 2021. Stop. Where is the order?
Yes, sir. Order is at page, my lords, 11. 11 and 12, my lords.
12, my lord.
Who was opposite party number 3?
OP3, my lord.
OP3 was Chief Engineer, National Highways, Odisha.
Odisha.
It should have been National Highway Authority of India, my lords. He is not Chief Engineer. He should have been your project director, National Highway Authorities of India, my lords.
From the order violation of which has been alleged in the present contempt application, it appears that the petitioner was granted liberty to make a representation before the opposite party number 3 as impleaded in the writ petition. That is Chief Engineer, National Highway. Right. So stop. It is an admitted position that the persons who have been impleaded as contemners in the present contempt application could not have entertained the petitioner's representation for the grievance which he had raised in the writ proceeding. So stop. The contemners were not holding the position of opposite party number 2 as impleaded in the writ proceeding. So stop. And
OP3, my lord. OP3.
contemner was opposite party number 3.
My lord.
Which contemner?
Chief Engineer, National Highway.
There is no Chief Engineer National Highway. So what is his name? How can we punish him?
No, I can. That is wrong, my lord.
Therefore,
Your petition is wrong, my lord. It is made wrong party, my lord.
then stop. Considering the admitted position, we are not inclined to proceed in the present contempt proceeding. Proceed further in the present contempt proceeding, which is accordingly dropped.
Item number 3. Wait, please, my lord. Lord, the order dated 21/3/2024 passed by the learned single judge, in which, my lord, the writ petition filed by the petitioner has been dismissed on the ground that he has approached the insurance company in late. But the fact remains, he has not approached the authority in late. Rather, he has approached in due time. That is the admitted case of the opposite party.
Just a minute, where is the order?
Order, my lord.
Annexure?
Annexure, my lord. 4. The operating portion is page 129. The order starts
Is it
from
private insurance company?
my lord. The vehicle was met an accident on 12th of February. My lord, the vehicle was given, my lord, to the workshop, my lord, on 20th of February itself. And the surveyor was sent on 24th of February. But the learned single, that is the admitted position, my lord, they have admitted in their counter also. That surveyor was sent on 24th of February 2020 itself. Page 118, running page, their counter I have annexed. The date of accident is 12th of February. I produced the vehicle on 20th of February. The surveyor insurance company sent the surveyor on 24th of February 2020.
Which page you want us to see?
118, running page 118. That is the counter I have annexed. The counter affidavit filed before the learned single judge.
Yes.
That 118, the right hand side, accident particulars.
Yes.
My lord, details of accident, 12th of February, 12/2/2020 at about 9 p.m. My lord, the place of surveyor was sent to Siddha Lakshmi Motors. The date of deputation is 24/2/2020 itself. The date and time of survey was 24/2/2020 and
Sir,
thereafter,
when did you claim the insurance?
my lord, on 20th of February.
Where is that?
My lord, I have Annexure 1. Annexure 1 is the document, the insurance company's acknowledgement. Page 27. This is the intimation to the petitioner. Page 27, my lord, running page. We inviting your reference to a letter dated 20th/11/2020 for the claim registered with us on 22/2020. I registered my claim on 20th of February 2020. And the surveyor was sent on 24th of February. And since the COVID was there, again, the surveyor was sent on 21st of June. And my vehicle has already been repaired. The insurance company rejected my claim saying that you have sold your vehicle. But in fact, I have not sold the vehicle. The vehicle till date, my lord, with me, and the RC book also with me, the valid insurance also with me. But the learned single just made a hard case, my lord, saying that why you approach the insurance company late. But the insurance company filed affidavit, counter affidavit saying that the surveyor was sent on 24th of February 2020 itself.
But there is nothing in this communication dated 3/11/2020 that you had sold your vehicle.
No, my lord. That is, in fact, they have rejected annexure, my lord, running page 59 is the rejection order, which was the impugned order before the learned single judge,
So after this, you came to the High Court.
my lord.
Is there no authority before whom you could have gone under the ombudsman?
I have not, in fact.
Then
I
you should have
filed,
gone.
I approached the insurance company since the
Insurance
vehicle is,
company, ombudsman is there for these things
since the
only.
vehicle, my lord, is ready and it has already been repaired as per the surveyor's report.
These are all factual.
So you should have gone to the ombudsman. They could
My
have-
lord, that is the admitted, they have admitted in their counter affidavit that on 24th, the surveyor was sent. But my read petition has been dismissed on the
Maybe-
ground that you have
maybe
approached
these
late.
aspects.
Is it at all maintainable against the private insurance?
And which company is this?
My lord, Tata
Tata
AIG,
AIG.
Tata AIG.
How could you? Petition itself was not maintainable. You, if you want, you can approach the ombudsman.
My lord, your lordship, my-
Learned counsel, this intra-court appeal has been filed assailing an order passed by a learned single judge of this court dated 21/3/2024, passed in WPC number 14898 of 2023. Full stop. Whereby the appellant's appeal writ petition has been dismissed. Full stop. The appellant had filed the said writ petition challenging non-release of insurance claim amount to the tune of rupees 3,97,449 against Insurance Regulatory Committee. Why this was Insurance Regulatory Committee was not party?
My lord, it was amended, my lord, subsequent to the read petition, it was made a party, my lord. But I am not up.
So as to make this writ application maintainable before this court.
And what was relief sought by you against Insurance
Against-
Regulatory Development Authority?
Not, my lord, I have not.
Learned single judge has dismissed the appellant's writ petition mainly on the ground that the appellant had approached the insurance company after lapse of 1.5 years from the date of the incident. And therefore, the insurance company had rightly rejected the appellant's claim. So, learned counsel appearing on behalf of the appellant has drawn this court's attention to annexure 1 of the present memo of appeal to submit that the claim was made soon after the occurrence and the finding recorded by the learned single judge is contrary to records. So stop. Learned counsel for the appellant has, however, counsel for the appellant, however, submits that the appellant approached this court without availing a remedy under the provisions of the IRDA Act. What is that? Ombudsman? IRDA Act.
The Samanthra, ombudsman is under IRDA.
IRDA and banks also.
Yes, no, so if it is not, where banking ombudsman different, insurance ombudsman different, banking ombudsman under RBI notes. So for insurance, it's IRDA notes. Its office is, I think, at Bhubaneswar notes, insurance ombudsman.
Without approaching the ombudsman. Full stop. Insurance ombudsman. Full stop. Next, considering the facts and circumstances of the case, and submission advanced on behalf of the appellant, and whether Tata was heard, the insurance company was heard,
Heard in the, before the learned single judge, you heard
then
and
we will have to issue notice.
my lord.
Issue notice. We cannot modify the order.
My lord.
Yes, let notice go. Otherwise, it will amount to modifying the order. Your claim has been rejected by learned single judge.
My lord.
So we cannot say that.
My lord.
Order another issue notice.
Item number 4.
Oh, my lord, this is public interest litigation, my lord. My lord, I have given a notice for the, Sand Sairat is there, my lord, at Potamundai block. It has not been put to auction since 2014-15. And illegal mining is going on there. For that, I have drawn the attention of the collector and given the notice. Since, my lord, they have received it in the month of, my lord, on, my lord, 9th of, it was 12th of February they have received, but no action till yet has been taken, my lord. It was last pushed to auction in the year 2014-15. Thereafter, it has not been. And that was also,
Your assertions in the writ petition are totally vague. As if you were dreaming that some persons were engaged
the
in.
problem is, my lord, I cannot go there for taking up pictures, my lord. They are mafias, my lord. My life is under also threat because I have filed this PIL. Because they are all the, my lord, police officials are also hand in gloves, my lord.
Maybe.
Yes.
Maybe if you have taken the risk of approaching this court, you could have taken the risk of
Your lordship may call it next week. Some mobile video has been taken, my lord. That I can produce by my lord pen drive.
That the fact leading to filing of the case is that it has come to the knowledge of the petitioner that group of sand mafias are lifting sand from so and so, and it has not been auction sold.
My lord.
So some knowledge you have derived. You don't disclose the source of knowledge, nothing.
This is my personal, I am the resident of there, my lord. I am a resident of that place, my lord.
So what is the source?
I'll produce that pen drive. I'll produce that pen drive, my lord.
Yes, what is your?
Environmental issue that he has to approach the legitimate.
No, he is not saying environmental issue. He is saying he is alleging loss to public exchequer. These kind of writ applications, Mr. Counsel. So
my lord, I understand. I'll produce the pen drive. I have got the pen drive. I did not, my lord,
I could not attach it with the photographs and
When the matter came to the knowledge, went to the Tahsildar, intimated him, nothing. Even digging of sand, Sayrat, absolutely nothing, all vague statements. So crores of writ applications of this nature can be filed.
there have been a bunch
That
of.
it has come to my knowledge that corruption is everywhere in the
No,
country.
it's not like that.
It is, yes, it is like that.
I'll produce that pen drive.
Completely vague.
I'll produce that pen drive.
Then you come with some definite.
I'll produce
accusation.
that pen drive. I'll
Where is the
produce.
question of?
Your lordship may keep it to next week. I'll produce that pen drive.
List this application on 4 weeks. Stop. Let counter affidavit be filed on behalf of the estate in the meanwhile.
Item number 5.
Lordship. Lordship, this is an application challenging the order dated 29/12/2023 of the National Consumer Disputes Redressal Commission, Your Lordship. Lordship, this item was taken up yesterday. Your Lordship had posted me a question whether this case is maintainable or not, Your Lordship. Your Lordship, this petition before the National Commission was filed under Section 19, read with Section 21A, Clause 2 of the old Act, Your Lordship, 1986 Act. 19, read with Section 21, Subclause A, Subclause 2, Your Lordship, which is appeals against the orders of any state and commission, Your Lordship. Your Lordship. Your Lordship, against that, there is no appeal provision, Your Lordship. Your Lordship, the perimeter in the...
Just a minute, just
Your Lordship.
How do you say this?
Your Lordship.
That this
Your Lordship, the appeal provision is at Section 27 of the old Act, Your Lordship, 1986 Act, Your Lordship. Apology, Your Lordship. 23, Your Lordship. Section 23 of 1986 Act, Your Lordship, the appeal. May I kindly read the same, Your Lordship?
What?
The appeal provision. Any person aggrieved by an order made by the National Commission in exercise of its powers conferred by subclause 1 of Clause A of Section 21 may prefer an appeal against such order to the Supreme Court within a period of 30 days from the date of order, provided that the Supreme Court may
No, you are reading which provision?
Your Lordship, we are under A2, that is appeal from State Commission, Your Lordship.
21A2.
2, Your Lordship. Lordship, 19A2, Your Lordship. A2, Your Lordship. Apologies. 21A2, appeal against order of any state commission. However, appeal is only against 21A1, Your Lordship.
Yes, hold that. 21A2, just a minute. Yes, so
Your
this was, you had filed the appeal
Your Lordship.
under 21A2.
Your Lordship.
All right.
Your Lordship, the perimeter provision in the new act is 51A3, Your Lordship.
No, let us see the appellate provision,
Your Lordship.
23.
Your Lordship.
Yes.
Your Lordship. Lordship, now there is no appeal provision in that regard. Your Lordship, similarly, the perimeter provision in the new 2019 Act is 58(1)(a)(3), Your Lordship, which is appeal from State Commission. Your Lordship, now the matter is no more res integra and it has been settled by the Honorable.
Yes, now there is no difficulty.
Your Lordship.
Let us see the order.
Your Lordship. Your Lordship, the impugned order is at page 165, Your Lordship, annexure 18.
Yes.
Your Lordship, the relevant final operative portion of the order is at page 170, Your Lordship. If I
Yes.
may kindly draw your attention to page 170,
Yes.
paragraph 8.
Yes.
As in this case, State Commission has given refund direction in the alternative along with compensation of 35 lakhs. We endorse the order of the State Commission with respect to the refund of the entire principal amount paid by the complainant respondent. Full stop. However, we are of the considered view that the interest of justice will be served if the compensation is paid to the complainant respondent in form of interest at 9% per annum with effect from date of each deposit. In addition, the complainant respondent will be entitled to litigation cost of 25,000, including 10,000 awarded by the State Commission. Accordingly, we modify the order of State Commission to this extent and direct OP1 petitioner herein to refund the entire principal amount paid by the complainant respondent herein, along with interest at 9% per annum from the date of each deposit till the date of refund, along with litigation cost of 25,000 within 30 days of this order, failing which it shall carry interest at 12%. Your Lordship, now the State Commission had rightly given a compensation of 35 lakhs because of the various difficulty and harassment faced by the petitioner over more than 10 years, Your Lordship. However, the National Commission has simply awarded interest of 9%, which does not itself build inflation, neither it builds the interest that I'm paying for the loan that I had procured during the taking of the.
That we cannot go into.
Your Lordship, I'll satisfy Your Lordship along with judgments, Your Lordship.
Sure.
Your Lordship. Your Lordship, since this was admission stage, Your Lordship.
What is this?
Your Lordship may kindly take up after lunch, I'll satisfy Your Lordship.
No.
Your
This
Lordship,
is
there
not the
was,
way. You are a young lawyer. You
Your
should
Lordship.
have come.
Your Lordship, apology, Your Lordship.
Please come tomorrow.
Your Lordship,
This is not the way.
apology, Your Lordship. Apologies.
Tomorrow.
Item 6.
Okay.
May I pray, can you date to tomorrow? Tomorrow, first hour, I have some difficulty.
All right. Day after tomorrow.
Oblige.
Oblige.
Item number 6.
Yes. Mr. Samantara, you have not given us the list of.
No, no, it's being prepared. By now, 320 cases, I have got the information that we have complied. I'm getting the list notes. I will supply to my lordships.
All right. So we will notify all those
Yes, Your Honor.
cases, not in the list. We shall notify those cases before listing,
Yes, sir.
so that the
The other
parties
side
may
can-
have the knowledge that these cases have been, in these cases, the orders have been complied with. Those cases can be listed one day and.
I am trying to get it by tomorrow, Milord. I will give it to.
But Mr. Samantara, there are 10,000 contempt
Yes,
applications
sir.
pending. So 327 is nothing.
No, right now I've got the 20. I'm testing for
All right.
more, Milord.
All right.
Because in fact, it's all, Milord, which I've searched for, it's only division bench. So far, single bench is concerned.
All right, let us see.
Yes.
The division many matters first.
Plus item 6, so far as first item 674 or 24 is concerned, Lords, it has been complied with in the sense, your Lordships had directed the petitioner to make a representation where he has filed an application under section 28 capital A of the Lords Land Acquisition Act. And he moved this on court for early disposal of that application. Your Lordships were pleased to direct, he will make a representation and it shall be considered. He has considered the representation and said that because there are a number of applications in the queue, his case cannot be taken out of turn because 2021 applications are also pending. So he has stated that it will be taken in queue. So he has complied that order saying that it cannot be taken up out of turn. It will be taken up as in seriatim.
So let us see the order.
Yes.
So if the order says that it should be taken up out of turn, then you will have to do it.
If you also look at
Running page 10.
page 9 is the order, Milord.
Running page 10.
Page 10 is
Page-
the direction. Page
yes.
10 is the direction.
Yes.
9 Lordship, paragraph 5, Lordship said that number of persons are waiting in the queue. So another problem is that the job.
Yes, so that has been disposed of. There is no direction that your case should be decided within a particular time. It says that that shall be considered. by an order dated 17/5/2023. The petitioner's writ application registered as WPC number 15412 of 2023 was disposed of with liberty to the petitioner to file an application before a special land acquisition officer, Khariar, for early disposal of his petition under section 28, capital A of the Land Acquisition Act. So stop. The court had further observed that in case such application was filed, the same would be considered and disposed of in accordance with law. The petitioner is said to have made a representation in the light of the said order of this court. First off, he has a grievance that till date the petitioner's application filed under section 28A of the Land Acquisition Act has not been disposed of. First off, it is evident from the order of this court that there was no specific direction for disposal of the said petition under section 28A of the Act. First off, it was rather the direction that if any application was filed for early disposal, same shall be considered in accordance with law. First off, compliance, I have filed. Mr. Samant Rai, learned AGA, has informed this court that the request of the petitioner for early disposal of said petition under section 28A of the LA Act has been disposed of by the special land acquisition officer, expressing inability to dispose of his petition under section 28A of the LA Act, as the cases of 2021 are pending and the petitioner's case is in queue. Stop. Next, in such view of the matter, we are of the opinion that no direction issued by this court by order dated 17/5/2023 can be said to have been disobeyed by the contemners. Stop. We are not inclined to proceed further in the present matter. The contempt proceeding stands stopped accordingly.
Next item also not same.
Same.
But third item here, there also, his case has been considered.
Second,
Third-
same.
Second, same, not same. In third item,
Yes.
that it has been found that in another case, he is entitled for enhanced compensation. And on 26/4/2024, estimate has been submitted to the government. So he has complied the order. It shall be paid in due course in accordance with law.
No, but we will ensure that the amount is paid.
Yes.
So what time will it take?
The estimate, because on 26/4 only it has been submitted, it take not at least also 4 to 6 weeks not so.
4 to 6 weeks, no? 4 weeks you take.
8 weeks loss grant. In the meantime, we'll see that it's paid loss.
Yes.
4 weeks ହେଲେ ହେଇଯିବନି କି? ଛୁଟିଟା ଆସିଯିବ। 4 weeks ହେଲେ
Is this
After the holidays,
4 weeks ଆସିଲେ ହେଇଯିବନି?
all right? Soon after the holiday.
holidays loss
List this matter on third. List this matter on 19th. Most of the court expects that in the meanwhile, the court shall, in the meanwhile, learned AGA shall seek instructions as regards full compliance of this court's order.
No.
Item number 7.
Yes, my lords, to see last order dated 10th of April 2024, passed by my lords, my lord. Order number 2.
Yes, what is the order?
Yes, Lordship said director will take instruction regarding compliance of Lordship order. Now I have received a letter from the Lordship that on 24/4/2024, Lord, they've decided to move the Honorable Supreme Court in SLP, challenging the order passed in writ appeal, Lords. So I only pray, Lords.
So let us see what is the date of the order.
Initial order is 10th of August 23. And the writ appeal order is October 23. Today, almost more than 8 months have passed, and when the content proceeding they are directed to comply with, coming with a letter that they have not yet filed SLP.
No, where is the order?
Yes, page 22, the order of the
Annexure?
That page 10.
Which annexure?
The order passed by the Honorable Single Judge, that is Annexure 1 at page, starts from page 8.
No, there must be division bench.
Division bench
Yes,
order,
I'm
my
saying
lord.
page 22.
Page 22, man.
Annexure 3.
Right, man. Page 22. Annexure 2. The writ appeal was dismissed. 10th of October 23, madam.
File your so-called reply.
Yes, week's time only I will file this.
2 weeks time is allowed for the state to file a so-called reply as to why contempt proceeding be not initiated against the contemptors for deliberate disobedience of this court's order dated 2/8/2022, passed in WPC number 40812 of 2021, read with the order dated 10/10/2023, passed in WA number 1421 of 2022. This is matter on 24th of June. Item number 8.
Yes, item number 8. Also, I only pray this is a settlement matter. There was a direction for settlement of the end. I've talked to the settlement officer. See, because it was Bhubaneswar, now it has been transferred to Kotak Zobra Milos. She needs some more time. We'll also take it up next week. I can do it, Milos.
All right, as requested on behalf of the contemptors, notify this case or list this matter on next Wednesday. Next Wednesday, Mr.
Yes, miss. Yes.
Item 9.
Yes, it has been complied with. It will also see calculation sheet has been not submitted to the state government for pay enhanced compensation, 2307.
And 2308.
So far, 2308 is concerned, same enhanced compensation recommendation has been made to the state government to make the payment.
And the other?
And the other is we have 2340 also. We have made recommendation for the payment of enhanced compensation. Because similar 2340, the representation has been disposed of in accordance with the direction of the lordship. So also can look at the order, Milos. Page 12, Annexure 5.
Paragraph.
Sorry, paragraph 5, annex, I'm sorry, my lords, paragraph 5.
The order has been complied with. There is no specific direction for
Yes.
payment.
No, there are no
There is
payment.
direction, there
For-
is direction for disposal.
Yes.
So that has been done.
Yes.
You can dispose.
2-3,
Hmm?
2-3-4-3, your lordship, are the different, second.
No,
contempt.
2-3-4-3 is different. 2-3-4-3, sanction has been met and you also may grant me.
Payment has not been made.
I'm saying that, how do you say, 2 is time to make payment, I'm saying, he's saying that, my lords.
Yes, sir.
All right, we will see your 2-3-4. So what is the direction?
2-3-4-3, my lords, if your lordships look at page,
Running page 12, your lordship. Paragraph 4.
the court directs the opinion number 3 to take decision on the letter dated 20 of opinion number 2 under
All
annex
right,
1
do it.
please.
Do it. Open say, wow. Except 2-3-4-3. All cases. Oh, it is. Land counsel appearing on behalf of the petitioner does not dispute that the order violation of which has been alleged in the present contempt application. Order passed by this court, violation of which has been alleged in the present contempt application has been complied with. Stop. The contempt application stands dropped accordingly. 2-3-4-3, how much time? 2 weeks.
2 is time.
As requested on behalf of the contenders, list this matter on 2 weeks to report full compliance of this court's order.
Item number 10.
For non-compliance of the order, under Annex 1, I am before your lordship. Your lordship may kindly turn to page 12.
Annexure?
Annex 1, page 12.
Yes.
Relevant portion. My lord, my land has been acquired for expansion of the SCB Medical College Road. And the assessment was made about my compensation, that is about 14 lakhs. But due to non-payment, I approached this honorable court.
Yes.
My lord, what of
It's
municipal court?
Municipal corporation notice has to go, we cannot appeal.
Yes.
So notice. Registered. And the speed post. Yes. 1 week,
Obliged, yes.
8 weeks.
For orders item 11.
In a disposed of writ petition. And that hearing of that review petition has been stayed by the honorable.
There are 2 IAs were filed by a state of Odisha, my lord. After the civil appeal was dismissed and review petition was dismissed by state, my lord. Thereafter, they filed to IA, my lord, where it was admitted and it was converted into a review petition that has been stayed by Honorable Supreme Court. My lord, these are the orders.
So what can be done now?
Now it is listed.
It should be listed after disposal of the asset.
Where is the stay order?
My lord, in the interim order staying further proceedings in IA number 12 and 14 of 2023 in OJC number 7386 of 99 and WPC 13313 of
So where is
2000.
the order? Oh, this I am seeing. Where is the order, stay order?
This one.
Original order, first order.
Date.
That is the my lord order. Interim order staying for the proceeding, my lord, it is in that way.
Which date?
This is, my lord, 24/7/2023, the first page. 24/7/2023.
So therefore, we want to know what is the first order? This is subsequent order.
No, my lord, this is the order, but this is the order that was passed, my lord, on 24th.
It says interim order is staying further proceeding IN number so and so shall continue till next date of hearing.
Yes, my lord.
There must be some order passed before this date.
No, my lord, this is the issue notice. This was the date on what the notice was issued by speed post, returnable in 6 weeks, and interim order staying further proceedings. This one, my lord.
So where is the first order?
That order,
No, it he order. It he order.
that is the order which
Yeah.
I will ask my,
Order in High Court.
that is
Order in High Court
against
to-
the order of this honorable court. They have preferred the appeal before the honorable appeals court, and honorable appeals
See,
court.
please read this order.
See, coach.
It says in
The original order is not, yes, original order. has to be
staying
there.
further proceeding in IA number 12 and 14 of 2023 in, IA number 12 and 13.
Yes.
Interim orders of 12 and
Yes,
13
Yes, ma'am.
These are the
shall
two IS.
continue. All
Yes.
right. Where are those interim orders?
These are the two IS pending before this honorable.
All right. List this matter on 8 weeks. Let us see. Item 12. Yes.
My lord, in item 12, there is a delay of 308 days, ma'am. But, my lord, now I take my lord to very three factors subject to my lord's.
No, but you may have to file substitution petition if you want to, because one of the respondents has died, is dead.
I'm sorry, my lord, beg apology. I will have to take steps for substitution. These 7, 10, 14.
So what do you want?
I will have to take steps for substitution. My lord may grant me 1 week time.
Then AGA, should we? In view of the office note regarding the death of respondents or one respondent,
My lord, I will actually check it from my lord's record and I will.
death of one of the respondents, comma, and AGA seeks adjournment to take steps for substitution. So, as requested, this matter on after vacation.
Particular date may be fixed, my. A particular date may be fixed, a particular date may be fixed, my lord.
Yes, date will be there. In the order, particular date will be there, my lord. Item number 13.
Stay has been vacated previously, that's.
Item 13.
Item 13, my lord, as my statement before this honorable court on 22/4 has already been complied, my lord. We have released them. They have been allowed to join. We have released. Then, my lord, may kindly hear this writ appeal on merit on any day.
What is this writ appeal about?
This is, my lord, we have challenged the 945 persons came together jointly to file a original application, and that was disposed of, my lord, in terms of another order which was affirmed by the Honorable Apex Court. And my lord has already seen, because we could not serve notices, because the names, only name and son of. So I requested the counsel who is appearing pursuing the contempt to accept notice, and he refused. Then I came up before this honorable court, and my lords have been pleased to stay the contempt proceeding. Thereafter, these two persons, they in their own term, in their own serial, they have been regularized and they accept it. So, my lord, these two petitioners, since they have accepted the regularization, and so, and accordingly, if out of 945, now we are going on, my lord, as per vacancy, we are doing it. So we'll be doing that one. But so far as merit that from 99, that, my lords, may kindly adjudicate.
Kindly fix the matter any other date for hearing, madam. Kindly fix the date, any other date for hearing, madam.
So why not today?
Today I have not appeared to all persons. I have not received Nama. Only 2 persons I have applied, but they are allowed to join in regular establishment.
No, but how can we ensure that they are here? There are so many persons, 945, file one application that is disposed of. All right, when do you want?
Kindly taken up after vacation, ma'am.
Right? All right. As jointly requested on behalf of the parties, let's put this matter on after. Yes, item number 14.
14 may I pray, my lord, because there is an order.
Okay.
I will draw my lord's attention to only one aspect. I want to bring this order, Maheshwar Raut versus State of Orissa, where number 3261C of 2014, which my lord will see at page 25, please. The mention.
Which annexure?
Annexure 1 at page 24, my lord, my kindness.
Yes.
This, I will produce this order before my lords. My lord may give me 2 days time.
So which order? The order is there.
No, my lord, this Maheshwar Raut, which has been referred.
Similar matter.
Similar matter.
Maheshwar Raut is not reported.
Maheshwar Raut is not.
Tribunal's order.
Oh, sure.
You must be having.
It was
cited this before the
it was given before the honorable single bench by right of a memo, my lord.
You have cited.
I have cited by, I have also supplied a copy by memo before the honorable single judge.
Where is it? You must be having another copy.
Right now I don't have, because notice has not been issued. It has come up along with the contempt. For that reason, I have entered my appearance. The notice has not been issued. There's a delay of more than 210 or 12 days. Because the order was passed on 26th October 2022, and the writ appeal has been filed on 22nd of August 2023. First, I have to serve me a copy on the IM.
Yes, we have.
Just come up.
Serve a copy.
No.
It's a batch matter.
That was best matter. My lord, while sitting in a single bench, also was heard this matter.
All right.
I pray that let it come next week. I will provide the copy of the order.
As requested on, as jointly requested, this matter on next week. Item 15.
My lord, this is item 15, is my lord, that is the Sarat Paradam. My lord, Sarat Paradam. My lord, Sarat Paradam, that is remanding. My lord, sort of copy. Cases are pending.
Before it was remanded back to
Man.
the single. So amount.
Yes, I have given the order.
uh,
My lord's order is also there.
remand. This matter is disclosed in batch after the.
Actually, my lord, it's not required because my lords will see hundreds of writ petitions were disposed of. These cases were pending, but the cases which were taken up, they were remanded. And after remand, the honorable single judge has heard the matter again and has passed a fresh judgment. So these writ petitions are of the first judgment, arising out of the first judgment. So this writ petition has to go back to the honorable single judge to. In fact, all these writ petitions are being remanded. Because earlier judgment no more remains now. Earlier judgment of the honorable single judge against which all these batch of writ petitions were filed, writ appeals were filed before this honorable court, that earlier judgment of the honorable single judge no more remains.
These persons were in that batch.
Yes.
So, but what should we do?
Same order.
So how can we pass same order? Because we will have to set aside an order.
As my lord pleases. My lord may kindly issue notice.
Then can you ensure that someone appears that may be in his interest also? Learned counsel was.
Yes, ma'am.
How many lawyers were appearing?
Different laws, but mostly 25 to 30 lawyers of all. They were appearing in all these batch of cases.
So how many such cases are there?
Now hardly, almost all are finished, man, because all this, it has gone back to that honorable single judge and it is heard and a reasoned judgment has come. That is Hemant Kumar Chotrai. Now, these orders which were now in appeal before this honorable court, these are the orders the honorable single judge was pleased to pass on the very first date because of the similar orders. That yes, they are covered by Sarat Parada, so you give them the.
So you want us to do same thing?
No, madam, because these orders no more remains. My lord will
These
appreciate.
persons are granted persons, whether they are entitled for pensionary benefits.
Yes, block grant.
Mr. Mishra, the question is that whether this order passed on 2/1/2023
My lord,
is in favor of respondents or not.
in favor of the respondent.
So if we set aside the order behind their back, then can they have no grievance that they were required to be heard?
And I will humbly say, technically they will have a grievance. On merit they cannot.
On merit, that's a different matter. We don't know.
My lord, we kindly issue.
Without hearing,
Your argument is common order which involved these petitions,
Yes.
these respondents.
My lord.
That having been set aside.
My lord,
Okay.
my lord, kindly.
oh, all right. So according to you, this order dated 2/1/2000, which order has been set aside?
My lord, here, in the my lord is holding now WA 2945.
Yes.
My lord,
WA 2159
2945.
2945.
or 2945. Yes.
My lord, kindly turn to page 44. This is the order. This is the
44.
order under challenge.
Just a minute. Annexure?
Annexure 2, man. Page 44.
There is an individual order. But now,
All these appeals which were remanded are this type of orders, all identical.
maybe.
So,
Let us follow. Issue notice. Or if you know who was appearing in this case, and if you can request, that will expedite disposal and final decision by the learned single judge.
Appears.
my lord, I will inform. My lord, will you take it up on Monday?
We
or
will take up on tomorrow.
Tomorrow.
Tomorrow we will take up.
My lord.
Have you accepted this Hemant Kumar Chotre case? Or you have again challenged it?
That is under challenge.
And then
That is under challenge.
here there is a huge delay. Now why should he suffer?
Issue notice.
Sir,
Delay
there
and
is a
take
huge
vote.
delay.
Item 16.
16, my lord.
And if he appears, all right, let it come on Monday.
My lord.
On Monday. In the meanwhile, please request him. If he appears, then we will consider what order should be passed now.
Item number 16.
Here, my lord, a delay of 12 days only. And we have challenged the judgment of the Honorable Single Judge by a declaration that the 1974 rules are applicable. My lord, now, my lord, I'll be linking this matter to the earlier matter. This is the stand of the state, ma'am, that certain rules.
All right, let us condone the delay first.
Well,
Will come for admission.
no,
12 days delay? No.
12 days. 12 days, my lord.
Issue notice. On limitation. That will help you on the point of limitation. Yeah.
Item
Page
7.
number 8568.
Item number 17.
Item number 17, my lord, there is a delay of 184 days. If the COVID.
Item number 17.
My lord, may kindly allow me to to submit no requisites for notice, my lord, on limitation. Delay of 184 days.
Issue notice. The point of limitation.
There is a regularization matter.
My lord.
Regularization.
My lord.
Of which post? Driver
My lord.
on daily wages since 97. He is working.
My lord. He's on
He will not regularize him since 97.
My lord, we consider that on after receipt of notice.
Item number 18.
18 on instructions of my client. Due to the further development, I'll not press these 3 applications.
Which are they?
Item number 18 has all those 3 writ appeals together.
All right. Learned counsel appearing on behalf of the appellate as instructed by his client seeks permission to withdraw
Balance.
WA 3138 of 2023,
3140
3140 of 2023,
and 3146 of 2000.
no, and WPC number,
The next page.
sorry. वो तीनों केस दे दो 3146 3140 3146. So these appeals are accordingly dismissed as withdrawn.
Item 19. In item 19, I am filing additional affidavit in course of the day. May I pray this matter will be taken up tomorrow?
All right.
Item 20.
Your Lordship, in item 20, I am for the respondent. Your Lordship, I will file objection regarding the condonation of delay application. Your Lordship, kindly grant me time.
So what is the delay?
Pardon, Your Lordship.
What is the delay?
300 days, almost 300 days.
So you have not filed objection.
Yes, Your Lordship.
File your objection as requested on behalf of which respondent? Which
Respondent
respondent?
Rosmita Das.
Respondent 1.
Respondent, only
Sole
respondent.
respondent.
Sole respondent.
Respondent. List this matter on 2 weeks so as to enable him to file objection to the limitation petition for condonation of it.
Item 21.
Oblige, Your Lordship.
Item 21, there is 121 days of delay. Already similar matters, Your Lordship has issued notice and that has been fixed to 3rd week of May.
All right. 3rd week of May cannot be fixed. Issue notice.
My Lord. On the question of delay.
The point of delay. Just कर दो उसे. Same way. When is that? 3rd May?
Third week of May, my Lord.
3rd week of May. जब भी date हो. You give us the date.
I'm giving the number. Number. My learned friends are appearing in those cases. Number
21 or 20?
Hello?
When is it fixed?
21.
21.
21. 21 and 22 also same number.
29 is the last date of before vacation.
No, sorry, that item, I am saying item 21, so not the date, my lord. Item serial number 20.
These headmasters matter matters are fixed to 2nd week of May.
I am giving the
And
number.
date.
I am giving the number, my lord, so that it will easier, my lord. I'll provide them.
Yes.
22.
Same.
Same. Item 23.
23 I have worked here. My lord, may grant me 2 weeks time because my lord will be taking up that Balabhadra Mati case, 432 matter at the first. So I will only pray for adjournment of 2 weeks or 3 weeks now. Thereafter I will.
As requested on behalf of the applicant, this matter on 3 weeks. 3 weeks means process the 19th June. 19th June.
Because I will be pressing only after my lord's order in the very first week.
Item 24. In item 24, someone has appeared on behalf of respondent. It can be disposed of in his presence, not. It's a matter regarding that rehabilitation, it can be disposed of in terms of that Bindu Sagar Samatre, but in his presence, he'll also take up two more matters so that matter can be disposed of.
Where is he?
His name appears.
His name is appearing.
He is regular practitioner here.
He is a regular practitioner.
He has come.
Yesterday he was sitting here, madam. Every day he was sitting. So
No, whether his name appears.
yes, madam, in the causality his name appears.
Mahanti. Ranjit Mahanti.
Madam, I will intimate your lordship, take up this matter tomorrow so that it.
Disposing it off because the name is appearing. He has appeared.
Yes, he has appeared.
All
madam,
right.
and
Then
It is in favor of. In his favor also.
in his favor also.
all right. Hindu sir.
Court of Hindu sir.
But you are telling that case before.
That
the
is
Supreme
pending for the Honorable Apex Court and that those cases notice has been issued and it
Court.
is.
Whether old rule or new
Oh,
rule?
yes, madam, that.
On the date of taking
on the date of consideration.
rehabilitation assistance.
Yes, madam. On the date of consideration, the rule governing the field, whether it will be applicable or on the date of death.
This civil case we have taken to.
Yes.
Item now 25.
There is no representation on behalf of the appellant. List this matter on. After a question.
Item 26.
And item 26, there is a delay of 12 days, madam.
My lord, my lord, maybe pardon, my lord, item 25, my lord, I could not log in, my lord. I may be pardon, 25, my lord.
Yes, please.
My lord, there is a delay in filing the writ appeal, my lord.
What is the delay?
My lord, the appeal was required to be filed, my lord, within 30 days. And the date of delay is, my lord, 7 days.
13 days delay. 13 days delay.
14 days. Yes, my lord. My lord, the order was passed on 27/2.
All right. You should notice the point of limitation.
Item 26.
Item 26, my lord, there is a delay of 12 days in filing the appeal.
You should notice limitation.
Item 27.
Item 27, my lord. Only 11 days delay. 11 days delay.
You should
And
notice.
that
Item 28.
In this case, my lords, this is connected to item 79. On 22nd April, I had mentioned, and you also observed that this matter will be taken up along with that matter to find out whether this is similar or not. There is a delay of 2 years and 4 months in this.
3 years.
Yes, I was not a party in that case. But after coming to know about that case, I filed a petition for recalling the order in WPC, and I have also intervened in the writ appeal. But under the wrong advice, I couldn't prefer appeal. But in appeal, I have given all the facts which I cannot place in the.
The last date of hearing, your lordship has had this
Yes,
matter.
your lordship has-
Item 75. My learned senior also represented on that day, and your lordship has directed that writ appeal so will be tagged with.
You also had passed order that on the next date, the court will consider whether the said appeal, that is writ appeal number 78, this writ appeal of 2024 should be taken up with the present appeals or not. That appeals are at serial number 79. I am the actual owner of the property. In all other earlier writ application, I was made party. But in the present writ application, in which the impugned order has been
How
passed.
can we condone the delay? All right, list this. How can both the cases be heard together? Here the condonation is, the delay is required to be condoned.
So only thing what I want to say, the facts which was not within the knowledge of the state government or the other appellant. That
No,
fact,
but in any case, who is appearing for the respondent in this case?
in respondent number 1 is the respondent number in 1.
Where is he?
He is not in this case. He is in the item.
Ask him to be present tomorrow.
Well, what I'm saying, it may be taken up along 79. There I can.
We cannot take
That-
up. See, the stage of the two cases, the stages are different.
May be taken up tomorrow.
So let it come tomorrow. In the meanwhile, please ask him to be here when the matter is taken up.
I will
He will
inform.
come in item 79. I will tell him. He will come in items.
I will be there in 79 also.
We can say, but if we reach 79, that is the problem.
In 79 also, I am intervened.
The problem is that if we reach 79, the matter is different, but if we don't, that is the difficulty.
But my submission is that if this case will be taken up or considered along with that, then it will be more convenient because this.
We understand that.
Yes.
We understand, but there is some procedure also which is to be.
Yes, yes.
Right. How can we direct?
No,
that this matter be.
I will
that-
inform him.
It
Please
is better, it is better if this matter, let this matter come tomorrow. You can request.
No, that I was submitting before your lordship. I will intimate, I will inform.
Or if that 79th matter is taken up tomorrow or today, then we will see what.
Yes, that is better.
Whether we'll take up then tomorrow. Yes.
Item 29.
Your lordship, in item number 29, there is a delay of 2 days, your lordship, in filing the document.
Condoned. Yes. Fresh.
Item 30.
Obliged.
My lordships, item number 30, the PIL which you had heard, my lords, was related to the admission of students of disadvantaged groups under the RT Act. My lord, the urgency of filing an IA in this case was, my lord, there are several cases of where these students have been allotted certain schools. I can, my lord.
What IA have you filed?
My lord, these students are being allotted schools. Lord, kindly look at this where a specific school has been allotted to a student. But when these students are going to take admission on those schools, the schools have denied admission to them. And these numbers of cases have increased. At the time of filing this IA, there were 70 cases, but now it has gone up to almost 100 cases where the government has assigned them a specific school. But the moment they're reaching the schools have denied admission.
Yes, who is for the estate? So we will take up the matter tomorrow.
Day after tomorrow,
All right.
I'll take instruction on them.
As requested on behalf of the estate, put up this matter on Friday.
Have you given a copy of that document to?
I will serve a
so that we
copy.
can read.
Yes. My lord, I have
Students
a
are denied, even though the state has allotted.
lot.
So that let them be aware of those students, so that they can get.
In that IA 5770, she has mentioned 5 schools. That in paragraph 5, I will take instruction on those schools so that the students have been denied.
Some specific.
Look, the ones which I have around 70 cases. But this is not just restricted to those 5 schools.
I cannot take what my one friend says. He's restricting to 70, but he has about that 5 schools. Unless she gives me a detail of where the students have been denied in respect of.
Why should she give?
Well, I have that giving.
It is your duty.
Yes, ma'am.
You should have a nodal officer.
We have a nodal officer.
See, the nodal officer should ensure.
Yes, well, on last.
Why these allegations? Or if there is grievance of this nature, there should be some officer designated for this.
On last occasion, in compliance to my lord's direction, director has appeared in person, has explained, and I will say he will appear in person also on Friday to explain the situation.
All right, let it come on Friday.
My
Let us see.
He will explain all the position, my lord. He will explain.
Will affidavit, your lordship, grant me a week's time only, I can put that. Not I've got the instruction.
What do you want?
I for the OP2, your lordship. I'm for the opposite party to your lordship, for the workmen. I filed an affidavit on 15/4/2024. Where I've stated that juniors to me are continuing, and I've also given the documents related to it, annexed it, relevant documents.
When did you file?
Paragraph 4 of that order, there was a direction to me to file an affidavit in response to that IM lordship. If I also look at
No, your lordship,
paragraph
I
4.
was directed to file.
No, he was
I
directed.
was.
Yes, junior to appeal content, sorry.
I have filed.
You have filed.
Yes, sir.
When?
15/4/2024. Actually, mistakenly, it has been stated as counter affidavit.
All right, that is there.
Para 5, your lordship.
Paragraph 5 of the counter affidavit.
Yes, your lordship.
This has been sworn by Premanand Manti.
Yes, your lordship.
Oh, this is something else.
And that might be a previous counter, your lordship, by the previous advocate.
This is not the
In
press
fact, I don't
affidavit.
press, your lordship.
You have,
I press
It
the
is
counter
stated by-
affidavit dated 15/4/2024.
it is stated by counsel for the respondent number 2
Yes, your lordship.
that an affidavit has been filed. On his behalf, in the light of this court's order dated 22/2/2000,
Yes, your lordship.
22/2/2024. The said affidavit is not there on record. 24 on 15/4/2000.
15/4/24.
The said affidavit is not there on record. First off, let the said affidavit be brought on record by the registry. List this matter on 1 week. What is this matter about?
It's a award passed by the labor court is under challenge, my lord. We getting, my lord, the direction for reinstatement and other things, my lord. Here, my lord, in fact, we have been complying 17B, there is no dispute. Only lordship, now she has filed that juniors are being allowed to continue, and even though he is a senior, his case is not being considered. That is the short question. If lordship, next week also it can be taken up and disposed of, because other cases lordship had also directed
On
to.
that basis, your lordship, there are several other cases which were disposed of, and they were also taken back in service with full back wages. And herein also the labor court has held that since juniors to him were continuing and procedures were not followed, that's why he has reinstated back him service with full back wages here, in which they have come up in challenge.
All right.
Item 32.
Obeyed.
But Cuttack Municipal Corporation had engaged the electrician. Allowed only for a period of 1/4/97 to 31/7/99. And thereafter it was not no more required. So that is why he was not allowed to continue anymore. So that is why the dispute was raised, and ultimately the dispute that was decided by the labor court, and that impugned order is annexed 8.
Lordship, may I pray, Lordship? Lordship, I am for the workman, Your Lordship, for the opposite party. Lordship, they have to comply the 17B, Your Lordship. As the award has been given that for reinstatement and the back wages. So far as the compliance of 17B, only the 1,95,944 rupees and 1,624, that is on 15/2/24 check, that was that have been paid to the workman, Your Lordship. But they have to pay more, your lordship, because the award has been passed in 4/29 to 2024, your lordship. Only part of payment has been given, your lordship. Kindly grant me some time to seek instruction, your lordship.
Not part of the payment. We have cleared the payment up to February. Up to month of February, we have.
When was the award made?
That award was made on 17/1/2012. And your lordship will find the order dated.
What was the direction? What was the
Direction
award?
was 25, that page 39. It's, lordship kindly see. Sorry, yes, 39 to 42.
So 25% of the back is it?
25% of the back purchase.
Till the award
And
becomes enforceable.
And
from,
pilot.
from the date when the dispute was raised, 4/8/2020,
2003, your lordship.
2003.
4/8/2003 till the award becomes enforceable, and thereafter he shall be entitled to full back wages till the date of his actual reinstatement, your lordship. Specific order has been, specific award has
No,
been
that
granted.
is an execution of the award.
So the
But the so far 17B is compliance, that your lordship will find the order that is dated 4/7/2014.
4/7?
4/7/14.
2014.
Where is that? Where is that? Which annexure?
No, that is the order of your lordships. That is the order of your lordship. Kindly, lordship, kindly see the order sheet. 4/7/14, passed in miscase number 23073 of 13.
Yes.
There shall be stay operation of the award dated 17/1/12, passed by the presiding officer.
You are referring to which order? 4/7/2014.
Yes, yes. That is passed in IA number, miscase number 23073 of 13.
Yes.
Lordship got it? Yes. There shall be stay of operation of the award dated 17/1/12, passed by the presiding officer Industrial Tribunal, Bhubaneswar, in ID case number 2 of 2011, till the next date, subject to compliance of section 17B of the Industrial Dispute Act. So as per the 17B, whatever the last pay drawn, at that rate it is to be paid. So we have already paid, and he is also saying that. Let's kindly see this receipt.
When was that paid?
Receipt.
When, date you can.
We have paid in total the amount.
When?
Your lordship, date 15 to 2024.
29/4/24. 29/4/24, we have paid the entire amount. But from the month of 4/7/14, from 4/7/14 till 29/2/2014.
Your lordship, that has been accepted on 29/4/2020.
But day for study of it.
Yes. The entire amount.
Your lordship, that has been.
Entire amount for the whole period.
Please read.
Yes, sir.
Please come this side.
This is the receipt, sir.
Yes.
That's 17 minutes.
So you did not comply with the order.
Whatever we have complied the order, paid the entire whole amount.
No, my lord, by dispute. Sorry. Sorry, sir.
Lordship, kindly see this receipt.
So this you did see, this order was 4/7/2014.
Yes.
It was directed that there shall be stay of the operation of the award. Right. Passed by so and so till the next date, subject to compliance of section 17, capital B of the ID Act.
Yes.
So you have paid this amount in 2024.
For the whole period.
Which period?
For from 4/7/14 to till 29/2/2014.
Till
29/2/2014. Only further 2 months, March and April payment.
29/2/2014.
For 24 or 14?
Oh, sorry, 29/2/2024.
Yes.
This 10 years, this 10 years you slept over.
Yes, for the whole period we have paid.
You slept over.
Yes. For ADC.
Yes.
Here, my lord, the order was passed, say the ID in industrial dispute case number 17/1/2012, the judgment was passed. They filed the case in the 2014. And what this Honorable High Court has directed for complaints of the 17B of the idea. They have never complied. And after a long gap of 10 years, my lord, even 12 years, they should have given me, they should have complied with effect from 17/1/2012, when the judgment was passed. They have given with effect from 2014 after a long gap of 10 years, my lord. So, my lord, it is not a fully compliance of your lordship's order. So, in view of that, my lord, we
Section
cannot-
17B says, in all cases that is happening during the pendency of the case. It does not say from the date of the award.
There is a decision, my lord, they cannot wait. They cannot wait. They should have filed it immediately. Otherwise, I am entitled to get the back wages with effect from the date of the judgment. Now they are saying, since we have filed the case after 2 years and the High Court has passed this order after, and they will comply. So it is not the fully compliance of the order.
You have received that amount?
Yes, I have received because I have no option.
There was no stay, so you could have taken up
No,
execution.
my lord, the matter is pending here.
Right, in all cases.
Yes,
There was
that
no
I-
stay.
That I know. Because my lord, may
Stay
kindly
is not
see the-
operative till you receive this.
No, because they have.
There
this
was
is the
no stay of
subject-
award.
Subject to compliance of the order that has been stayed.
Sometime
So I
workmen,
am entitled to get the back charge at least with effect from 17/1/2012.
my lord,
They have not
sometimes the
paid.
workman is not available. While you make the intimation, they
No,
don't
no, no,
receive.
Each and
That
every.
is why we
month,
pay
my
the
lord-
amount whole of the.
So senior members of the bar
Sorry, my lord, sorry.
can
sir.
be,
It is-
can address the court simultaneously.
My lord, sorry.
This can be done by others, but not by you. So let us hear you first. You are
My
the.
lord. My lord, here, so far the
according
award,
to you, he is not entitled. He was not entitled to the amount for the period before the writ petition was filed.
yes,
Because he was. Let us read the language of 17B.
yes. Where in any,
Yes.
where in any case a labor court, tribunal or national tribunal by its award directs reinstatement of any workman and the employer prefers any proceeding against such award in a high court or the Supreme Court, the employer shall be liable to pay such workman during the period of pendency, my lord.
Yes.
I am emphasizing on that.
Liable to pay. Mr. That means that you are liable to pay during the pendency of the proceeding.
My lord.
It is not that the payment due to him before the filing of a writ petition, that shall not be paid to him.
But that is my submission.
That is your submission.
Mine.
That may be your submission.
So during the pendency, my lord, once it is entertained, from that stage, 17B has to be
It's a
paid.
gross case.
Pardon?
It's a gross case. Sir.
But my lord, it is being followed in all cases.
Yes.
Because he files the affidavit that he is not engaged in the, then only this 17B.
If he is not gainfully employed, you will say.
So how will he survive?
Because he has, my lord.
How will he survive?
Well, this is the condition precedent that provided that where it is proved to the satisfaction of the High Court or the Supreme Court that such workmen had been employed and had been receiving adequate remuneration during any such period or part thereof, the court shall order that no wages shall be payable. But he has to file an affidavit before the court that he was not gainfully employed. So he has filed the affidavit much after that. He has to also comply these conditions that during the period of pendency of such proceeding in the High Court or the
Sir,
Supreme Court.
the fact remains
Yes.
that the order of the Labor Court was passed in 2012.
Yes.
You
Right.
filed the writ petition in 2014. An interim order was issued, was passed by this court to the extent that the award shall remain a state if you comply with the requirement of Section 17B. You have denied payment of the salary and anything from 2012 to 2014. According to you, had you filed the writ petition in 2023, would you have claimed that for these years he will not be entitled to payment anything because of 17B?
Well, normally the 17B payment is made during the pendency of the writ petition.
During the pendency, you have to pay, but you have to pay the full amount. During pendency does not mean that during the pendency you will have to do that. You will have to comply with that. This is the requirement of law. You did not comply with that, and therefore you cannot take advantage of the interim order 1.
My lord, your lordship kindly see, he has filed the affidavit because it is a condition precedent. He has to file affidavit that he was not gainfully employed. So that affidavit he had also filed. To comply that order, he is also required to file an affidavit to the effect that he was never nowhere gainfully employed. That affidavit he has not filed. And affidavit by such workmen had been filed to that effect.
Yes, when did you file your affidavit?
Each and every occasion, my lord, intermittently, he has filed the affidavit, he has given the no objection, no employment certificate before the authority. And that too,
Mr. Jana, you have filed affidavit on 8th February 2024.
Here I have filed, but each and every occasion intermittently, he is not
Sir, please read Section 17B. If you are trying to take advantage of 17B, you will have to fulfill the requirements of Section 17B. Please read it.
Yes, my lord. Here, your lordship, he can intermittently, he gave his no employment certificate before the authority. My lord,
authority, please read it.
In such court.
And subsequent, recently he had filed here. Of course, your lordship.
Recently, then
Yes.
that
And
is
that to my
different.
lord.
Then what is being given to you is much.
February 24.
24, I have filed affidavit here.
All right, then they have paid it.
And that to my lord,
I think
your lordship, as regards the,
Senior counsel is correct.
my lord, as regards the area with the.
May I address your lordship on the point of merit, lord, because it is a covered matter.
Just a minute. Let us see first. Where is the affidavit? Where is the affidavit? Bureau additional affidavit. So you cannot blame non-compliance of section 17B. There is no doubt about that. But yes.
Last occasion, he should have paid the amount.
Lordship kindly,
That was, yes.
yes. Lordship kindly. Kindly come to the impound hour, page 39.
Annexure?
Annexure 8.
Yes.
Well, the government of Orissa in the Labor and Employment Department in exercise of power conferred upon them by subsection 5 of section 12, read with clause D of subsection 1 of section 10 of the Industrial Dispute Act 1947, for short, the Act have referred the following disputes. Whether the termination of the service of Sri Suresh Kumar Nayak, ex-electrician, with effect from 1/8/99 by the management of Cuttack Municipal Corporation, Cuttack, is legal or justified. If not, to what reliefs Nayak is entitled. In this claim, in his claim statement, the second party workman has asserted that he has worked as an electrician, skilled workman, in the establishment of the first party, that is Cuttack Municipal Corporation, Cuttack, for the period from 1/4/97 to 31/7/99, and that on 1/8/99, the first party refused employment to him without compliance of section 25F, 25G, and 25H of the Act. He has further asserted that all the employees who were appointed along with him are still continuing in their employment under the first party. He has referred to letter number dated 15/12/2000 of the Government of Orissa Housing and Urban Development Department, wherein there was a direction to disengage all DLR NMRs engaged after 19/5/97. In this regard, it is the stand of the workman that since he was engaged on 1/4/97, that is prior to 19/5/97, the instructions contained in the letter is not an impediment for his reinstatement. Further case of the second party is that since his retrenchment, he has been going without any gainful employment. With this assertion, he asks for the reinstatement with full back wages. The first party management, on being served with notice to file written statement, appeared before this tribunal and repeatedly took time to file written statement. At last, the petition for the time filed by it on 7/10/11 was rejected by the tribunal and the first party was set ex parte. Then, second party workman has this affidavit evidence. The second party has he has stated that during the period from 1/4/97, employment of the first party without any break, and thereby he has completed 1 year of continuous service. He has further stated that on 1/8/99, when he reported for duty, the management refused his employment. In support of his contention, he has exhibited a series of pay cards which are marked Exhibit 1 series. He has also exhibited one experience certificate purportedly issued by the then Assistant Engineer Electrical, Cuttack Municipal Corporation, certifying that the second party had been working in the electrical section of the corporation since 1/4/97 till the date of issue of the certificate, that is 5/7/99. Exhibit 1 series reflects that the workman has received wages for his management under the corporation during the period June 97 to January 2009. There is nothing to disbelieve the pay cards. On the basis of the particulars reflected in the pay cards, it can be said that the workman has completed 1 year of continuous service under the first party.
What is the illegality? We have read the order.
My lord.
What is the illegality?
Illegality is that, my lord, it has been referred, kindly see, your lordship, the case of one Srodhakar Mahanti has been relied. Your Lordship will find.
Yeah.
Paragraph 6 of the
Yeah.
order. Is similarly placed employees.
Yes.
I am just, Your Lordship, kindly permit me to read that.
Yes,
Para
yes.
6. The second party service was terminated with effect from 1/8/99. The copy of the Conciliation Fellow report reflects that the workman raised the dispute by filing a complaint before the Labour Commissioner 4/8/2003. Thus, there was a delay of about 4 years to raise the dispute. The workman has not shown as to why there was such long delay. The workman was under the employment of the first party for a period of about 2 years. Since the date of his termination, the workman has not rendered any service to the first party. However, he has taken a plea that his co-worker, namely Srodhakar Mahanti, whose service was illegally terminated by the first party, has been reinstated in service by the management on the strength of the award passed by the presiding officer, Labour Court, Bhubaneswar, in IAD case number so-and-so. The second party claims to be an electrical technician. It cannot be believed that an electrician would sit idly without any gainful employment, considering all these facts and circumstances, so-and-so. Well, here, Srodhakar Mahanti, he is claiming the similar footing. The Srodhakar Mahanti judgment, Your Lordship, kindly see Annexure 7. This was challenged in this Honorable Court, and that is Annexure 7, page 33.
Yes.
Lordship, kindly see this judgment comments, page 35. Ultimately, my Lord, page 38.
Yes.
In view of the above settled position of law, this court modifies the impugned award dated 27/12/8 passed by the presiding officer, Labour Court, Bhubaneswar, in ID case number so-and-so, in exercise of the jurisdiction under Article 227 of the Constitution, as the compensation in lieu of reinstatement as proper to daily wager who has completed 240 days. The petitioner management is directed to pay a sum of ₹80,000 as compensation to opposite party number 1 workman within a period of 6 weeks from today. And this judgment has been confirmed also, my Lord, that has been also confirmed in the writ appeal.
Yeah, that's your submission.
What I beg to submit, my Lord, now, in view of the nature of job, it's a completely DLR employees, no substantive employment was given, and under the Municipal Act, Section 73 says that without sanction of the government, without permission of the government, there cannot be any regular recruitment. Only a temporary, for emergency nature of work, temporary engagement can be given. Supposing it is found that 25F not followed, then in that case, it is not a rule always for direct for instatement with backwards. Rather, it can be compensated because taking into consideration the nature of the job and the nature of employment, nature of recruitment. And that is the judgment, and Your Lordship will find there are series of judgment. This is also, so that Your Lordship can modify only to the extent of compensation. This is also the Supreme Court judgment. This has been referred also in other cases.
Yes.
Yeah.
Yes. Now you say what you have to say.
Here, my lord, as regards the compliance of the Rule 17B.
That's all.
Anyhow, now, my lord.
And other judgments I am giving also, my lord.
On the point that instead of reinstatement, compensation should have been.
Maybe.
There's so many decisions.
So many. Obliged. I'm grateful to you. Only that is.
Your Honor, admittedly 25F has been violated. And that too, what my lord in fact is submitting that Srodhakar Mahanti who has been this.
Mr. The tribunal was of the view. The It's quite perfunctory. It doesn't deal with anything.
No,
It says you are not entitled to, because you don't have any explanation for 4 years of delay.
no,
And
here
then
not
it says
4 years.
because of Sudhakar.
Sudhakar is
So-
4 years, but not in this case. I was employed, I have filed the dispute in the 2011 and till 2009, I was working. That is Sudhakar has filed case after 4 years, not this person. And that was Sudhakar, whose judgment has been set aside. The single,
No, let us see. Let us
Yes.
see again the order.
my lord, may kindly have a glance. Because they have already placed the award. Here,
You come
award,
to
my
page-
lord, there is a finding that.
Mr. Jana,
My lord.
come to page 38, that's
My-
Sudhakar para 6.
In view of the above settled position of law, court modifies the impugned award dated 26/12/2008 passed by the presiding officer, Labour Court, Bhubaneswar, ID Sanchez, in excess of jurisdiction under Article 227, as the compensation in lieu of reinstatement proper to daily wager who was complied 240 days. The petitioner management is directed to pay a sum of rupees 80,000 as compensation to the opposite partner or worker within a period of 6 weeks. This is as regards the Sudhakar case. Sudhakar has filed the case after 2 years of disengagement. They have not, and the petitioner, the case of this opposite party number 1 is that that is your lordship will find the finding is that he has worked till 2009 and he has filed the industrial dispute in 2011. So there is no delay. Apart from my lord, the Sudhakar Mati, even if the order has been passed, now my lord, I often instruction for my client that that person is still continuing in Cuttack Municipal Corporation. He is still continuing.
Maybe continuing.
Yes. So my lord, if he is continuing, even after so the petitioner is also entitled to get the same relief. He is continuing. Sudhakar, even if the order has been set aside, now still he is continuing.
Please come to paragraph 6
Paragraph
of the award.
My lord. The second party's service was terminated with effect from 1/8/99. The copy of the Conciliation failure report reflects that the workman raised the dispute filing complaint before the Labour 4/8/2003. Thus, there was a delay of about 4 years of the raise of dispute. The workman has not shown as why there was a long delay. The workman.
So this is one finding.
Yes, sorry, my lord, because some places it has been mentioned 2009. But my honored friend, anyhow, my
So
lord.
this is one aspect.
Yes, yes, yes.
The other aspect is, just see, the Labour Court comes to conclusion that he was under employment for period of about 2 years.
Yes, ma'am. First party for a period of about 2 years. So the date of the termination, the workman has not rendered any service to the first party. However, he has taken a plea that his co-worker named Sudhakar Mahanti, whose service was illegally terminated by the first party, has been reinstated in service by the management. And now, my lord, of course, now this Sudhakar Mahanti is still in service at Cuttack Municipal
It is
Corporation.
different. We are not here to have evidence.
My lord.
That must be parallel.
That, yes. So just decide. Let there be an order passed with the consent of the parties. What has been paid to him? What has been paid? What amount has been paid to him?
But
Sudhakar Mahanti, 80,000.
No.
no,
Is-
that
now-
he has received yesterday. He has received 2 checks. One is 194,000, 195,000, 1,95,000 some odd. Another is 1,600 some odd. Yes, yes. Here, my lord, one check.
More than 2 lakhs were
2
already
lakhs.
received.
More less than 2 lakhs.
No, more than 2 lakhs.
No, my lord. 1,95,944 plus 1,624 confused.
1,600.
1,600, ma'am. That is 1,624. Just less than some
Less
2
than
lakhs. Some
2 lakhs, so more than 2 lakhs now.
Which is a
We are not satisfied.
Yes.
We are inclined to interfere with the award.
So my lord, is entitled to compensation if the lordship
Is entitled to, you can get 10,000 more. Get rid of the, yes.
80,000 now, my lord, at this after a long gap of.
No, that was your fault. You were in employment.
No,
You were in employment, therefore you did not file any affidavit.
each and every occasion he went to. Anyhow, my lord, that of course we should have, but.
Yes, with the consent we are disposing of. For such matters, 10,000 you pay him 10,000 more.
Yes.
The
This is 80.
Huh?
I think, my lord, at least 2 lakhs more should.
then we will have to consider the this thing.
Because you have
Legality of this. This is thoroughly illegal.
I leave it to you, lordship.
In the present writ application filed under Article 226 of the Constitution of India, the Cuttack Municipal Corporation has questioned an award dated 17/1/2012 passed by the presiding officer, Industrial Tribunal, Bhubaneswar, in industrial dispute case number 2 of 2011. Stop. The present order is being passed with the consent of the parties. Stop. It is noted that when this matter was taken up, coming. It is not working. No. This was. This court had passed following order in miscellaneous case number 23073 of 2013. Miscellaneous case order sheets. Stop. Next, in compliance of the said order, an amount of rupees 1,95,000 plus 1,600. It comes to 1,96,600.
1,97,568. 1,97,568.
568 has been paid by the management. Stop. It is worthwhile noticing that the opposite party number 2 did not file an affidavit condition precedent for
OP1.
OP1.
Yes.
OP1 condition precedent for payment of wages in compliance of section 17 capital B of the Industrial Dispute Act on date When did you file the affidavit?
8/2/2024, I have.
8/2/2024. To the effect that he was not employed in any establishment during the period in question. During the period in question. So stop. Several grounds have been taken to assail the impugned award passed by the industrial tribunal. So stop. However, taking into account the fact, however, with the consent of the parties, this application is disposed of with an observation that the opposite party number 1 shall be entitled to compensation instead of a reinstatement, and he shall further be entitled to payment of an additional sum of rupees 10,000 over and above what has been paid. That is 1,97,000, so and so. So the amount must be paid within 1 week, 2 weeks. 10,000 you pay 2 weeks.
This submission is by around 80,000. This Honorable High Court has said 80,000 compensation. I require that at least that amount may be paid. Because this Honorable High Court, while disposing matter, has said in lieu of reinstatement is entitled to get 80,000 compensation apart from the back wages. Here, madam, at least that.
See, you did not work.
I did not
You
work.
got 1,97,000 something
That is
by virtue operation of 17B. You did not comply with the requirement of section 17B. You just file an affidavit, and that affidavit does not show that you had not been gainfully employed throughout the year, right from, so, and therefore we want, we can address the merits of the case. The grounds which have been taken, we can consider. We are not.
Since Lordship is inclined to dispose of the matter, and I pray, my lord, that compensation amount should.
20,000 crore. 20,000. 20,000.
I may please your lordship. Lordship, matter relates to the promotion of mining executive of Coal India Limited. Pursuant to lordship's earlier direction, we have submitted the promotion policy. Promotion policy of the Coal India Limited. Mr. K.P. Mishra, Senior Counsel, will address your lordship. Lordship, kindly take it up next week. We have filed the promotion policy of the Coal India Limited. The admitted junior is promoted earlier to the petitioner.
So what do you want?
We want that our promotion should be antedated with effect from the date the admitted junior has been promoted.
Whether you want to argue or you are waiting for your senior to come.
Senior to come, my lord.
Say that.
Yes, my lord.
But this is 2014 matter.
Only on Friday or Monday, my lord. Next Friday or Monday, as lordship pleases.
As requested on behalf of the petitioner, this matter on Friday. 34.
Item 34, may I please your lordship? Your lordship, it is the matter that your lordship had heard at length regarding the challenging the termination of the service of the petitioner
who was appointed prior to 1993, when acquiring B.Ed as a minimum qualification was not a prescription, and later on it was introduced, Your Lordship, and as a result, I had relied upon a judgment, Your Lordship, Vivekananda's judgment, and Your Lordship had heard the matter at length. I had referred to this judgment wherein it was stated that during the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained scale of pay. Untrained scale of pay, however, was admissible to him. The applicant being a pre-1993 appointee.
So, but why was the matter adjourned? Oh,
You have cited one judgment.
Yes.
But that was, and at the end, it was said that it
No,
is
Your Lordship,
compared to that case.
No, Your Lordship has said that in respect of approval, so that was not preceded for others.
That is Manmohan Tripathi.
Yes.
You have.
Yes, my lord. Taking the account as he has continued, so Your Lordship has said it will not be precedent for others. And the principle has been decided in that case, taking into account that Vivekananda Naik case, why that is not applicable. And if Your Lordship will go through that order of the tribunal, everything has been.
Your Lordship, both the judgments have been passed by division bench, Your Lordship. Vivekananda's judgment has not yet been referred to a larger bench, or it has not been decided as of yet. And also similarly placed persons had their services had been approved, relying on the same judgment, Your Lordship.
so let me recapitulate, I'm forgetting. So what was the matter about?
Yes, Your Lordship. Your Lordship, the petitioner was appointed in the on 30/10/1990 as
30/10?
1990
Yes,
as an assistant teacher, Your Lordship.
yes.
Thereafter, the management of the school was taken over by the government, Your Lordship,
Even.
on 16/12/1994.
Yes.
Thereafter, the government approved the
What was your
post.
qualification?
Your Lordship, as of then, the qualification, there was no minimum qualification, Your Lordship.
Untrained.
Yes, Your Lordship, untrained.
Then?
Then in 1995, Your Lordship, the government approved the post of additional section teachers in 29/7/1995. It's there at Annexure 3, Your Lordship.
Government approved?
The post of additional section teachers.
Here.
Thereafter, on 12/6/1998.
So how is this relevant? When your, all right, next page, yes?
12/6/1998, the appointment of the petitioner was approved.
Against which post?
Against the post of additional section teacher.
Yes.
With the condition that he must acquire the minimum qualification within 2 years, Your Lordship.
What is the minimum qualification?
Minimum qualification was CT training or B.Ed, Your Lordship.
So your approval of appointment was conditional.
Yes, Your Lordship.
Then?
Your Lordship, thereafter, many similarly situated persons have been approved. on the basis of the judgment that I have referred to, Your Lordship.
Where is that judgment?
Vivekananda Das versus State of Orissa, Your Lordship. Submitted.
Just a minute. Yes. What is there?
Your Lordship, paragraph 5 of the judgment.
Digital page.
It is there.
Digital.
What has been held?
Your Lordship, paragraph 5. During the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained scale of pay. Untrained scale of pay, however, was admissible to him. The applicant being a pre-1993 appointee, his appointment cannot be disproved merely because he does not possess the training qualification, which is B.Ed, Your Lordship.
So this is of which year?
2001, Your Lordship. Decided on 18/12/2001.
Yes. Vivekananda Das, there is no dispute.
No, Your Lordship. And since the case law squarely covers my case, Your Lordship, my contention is that that my termination of service should have been quashed, Your Lordship. Since it was not quashed by the Odisha Administrative Tribunal, hence I have challenged the order.
Yes. Then what happened?
Another judgment you are citing, that is Raghunath Prasad Harichandan,
Yes, Your Lordship.
93/2002 CLT,
Yes, Your Lordship.
Division Bench decision of this court.
Yes, Your Lordship. Similar judgment.
In which case?
That is available at.
The Raghunath Prasad. Yes. Why do you rely on this?
Your Lordship, I'm relying on this because since I was appointed prior to 1993, Your Lordship. And back then, the minimum qualification of B.Ed was not a precondition, Your Lordship.
Yes. That's all?
Yes, Your Lordship.
Yes. And what, how, you are aggrieved by what?
Your Lordship, I'm aggrieved by the order of the tribunal. Order dated 27/1/2012, which is at Annexure 7.
Dated?
27/1/2012.
Yes. What the tribunal has held?
The tribunal has upheld the order of termination of service of the petitioner, Your Lordship.
So therefore, termination from service is the cause
Fine.
for action.
Yes, Your Lordship.
Where is that?
Your Lordship, Annexure 7 is the impugned order.
Your order means termination?
The order of the tribunal, Your Lordship.
No. Your termination
Termination, Your Lordship.
service.
That is Annexure 6, page 21.
Yes.
Annexure 6, page.
Yes, Your Lordship. Page 21.
Dated
9/3/2001.
19?
9/3/2001.
So what can be done now? The order of the tribunal is 27/1/2012.
Your Lordship, my prayer is that, Your Lordship, the delay cannot be attributed to the petitioner, Your Lordship. The petitioner has continuously fought.
No, we are not doing that. We are thinking that what relief, if at all we entertain your writ application, what relief can be granted?
Your Lordship, the petitioner still has 2 years. If he is still reinstated, he can, Your Lordship, have served for 2 more years, Your Lordship.
And when did you file your application before the tribunal?
In the year 2000, Your Lordship.
No.
2002, Your Lordship.
2000.
Yeah. After termination, Your Lordship.
Yes, what is your submission?
Well, may I draw my lord's notice to Annexure 7 order of the tribunal?
Yes.
Before drawing my lord's notice to order of the tribunal, I'll just bring my lord's notice to the standard staff stepping pattern for high schools, my lord. That is standard stepping pattern. Why I am saying that a learned friend is submitting that.
No, let us see the impugned order first.
Yes, ma'am. Yes, ma'am.
Impugned order not of the tribunal, but the order of termination.
My lord. Annexure 6, page 21.
So that was the only reason.
Yes, ma'am. Then I'll draw my lord's notice.
No, just let us understand this.
Well,
as he has not complied with the condition imposed by the office order so and so to acquire, this was the only reason.
Yes, ma'am. That was the approval order. May I draw my lord's notice to that approval order, my lord?
Yes, we understand. So that was a condition that he must acquire that qualification within
2 years.
2 years. So that was the only ground for termination of service, not on the basis of or because of the staffing pattern.
Yes, ma'am. Why I am saying stepping pattern? In the stepping pattern, the post is trained graduate. So there is no post available for untrained. So that was the condition. May I draw my lord's notice the approval order? Approval order is at page 11 of my counter. Sorry, my lord, that I have not.
Yes.
Lordship got it, man.
Yes.
Lordship, see that order dated 12/6/1998. This was the approval order.
Yes.
In pursuance of GO number 12631/SME dated 29/4/1995, GO number 19161/SME dated 31/7/1996, read with director letter number 9783 dated 22/2/1993, and without prejudice to the claims of others, the appointment of the following trained/untrained additional section teachers made by the concerned managing committee of the said school noted against each are hereby approved with effect from 7/6/1994 in the prescribed scale of pay as detailed below. That next line is important. They should acquire BED training within 2 years from the date of issue of this order, failing which approval will be cancelled automatically. And this is the order on 12/6/1998.
Yes, madam, you have no case.
Your Lordship, since that is the condition, Your Lordship, to that I had already submitted in my rejoinder before the learned tribunal that the petitioner had approached, Your Lordship, there was this, Your Lordship, that the petitioner could acquire the qualification while in service, and that is why the petitioner had approached the authorities, which was not considered, Your Lordship. And that index card also had been annexed before the tribunal, showing that it is not that the petitioner had not tried to acquire the qualification. It was such that it was shown as if the chance was given by showing that you could acquire the same in service. However, due to the delay reason best known to the department, it was not approved, Your Lordship. The
So you
petition,
could have come then and there,
Your Lordship,
that this is the
before,
condition and you are not getting.
because before that, the petitioner was terminated, Your Lordship.
No,
Since
you are not terminated before that. You were your appointment was approved on 12/6/1998, and your service was terminated in 2000.
9/3/2001.
2001.
Yes, Your Lordship, the petitioner had applied for it in 2020, Your Lordship.
2020, no, 2000.
2000, Your Lordship. I beg your pardon, Your Lordship.
After,
2000.
how could you apply? Why didn't you apply in 1998 itself? 1999.
Because, Your Lordship, the in-service training was for 2000 to 2001, Your Lordship, as per their own submission. It was from 2000 to 2001, and when the petitioner got the chance, he applied at the first instance itself, which was not, no reply was given to that. So, Your Lordship, when petitioner approached the tribunal, the case was such that the petitioner had tried to acquire the degree, the qualification within 2 years. Since it was not possible, the petitioner was asking for some more time, Your Lordship, so that the petitioner could acquire the same. However, it was dismissed, Your Lordship. And in the meantime, more than 10 years have passed.
Hello, may I submit in reply to that one? Your Lordship, may see page 9 of my last paragraph.
Page 9 of your counter affidavit.
My lord, but that
your statement.
Yes, that I have annexed that counter filed before the state administrative tribunal, that page 9 of which was filed before the state counter, that has been annexed A/3 to my counter.
Yes, it is there.
See that last, the applicant's name was sponsored for undergoing BD training during the session 2000-2001 for consideration of SCRT, but the applicant did not avail the opportunity to get himself trained, hence the
Yes.
She was also sponsored for undergoing BD training, but she did not avail that opportunity.
Your Lordship, admittedly, that is what I was submitting, Your Lordship, that since I got the opportunity, I applied, and since I did not get any response from the same, I could not acquire the qualification, Your Lordship. Which means there is no dispute in the fact that I had in fact applied, which Your Lordship may find in page 5 of my rejoinder. It's the acknowledgement slip.
So where is that? That he was sponsored? Where is the document?
Document she has annexed, that is the acknowledgement he has received.
Inspector of Schools
Yes, ma'am.
has given this acknowledgement.
Yes, ma'am. That is the sum number 65.
So your application for
Admission into BD
course
yes, ma'am,
has been
received. Your index, you are requested to quote the index number and correspondence by right.
Which annexure?
Well, in his rejoinder, she has annexed that annexure 8, page 5.
rejoinder page 5.
And next page, her name finds place at Kabi Pradhan, so and so.
Just a minute. Rejoinder. There is only one rejoinder, no?
Well,
Rejoinder is only one. So page 5 of the rejoinder.
Yes.
My
sir.
lord.
Given by the who is the person who was given this acknowledgement, principal or inspector of school?
Normally, inspector of schools recommends.
But there is a stroke in principal or inspector of schools. Somebody on behalf of principal or
By
inspector.
inspector of schools, oblique technical education for, he has sent for technical education in this year to Odisha.
Director. Director T and SC.
My lord.
So what is mentioned in this acknowledgement?
That has been communicated, but he has not given the details. That means he has been intimated for undergoing BEd training.
Your Lordship, this means that the petitioner had applied and it was duly acknowledged, Your Lordship.
No, when nothing is apparent from this.
Next page. That is the next page.
Next page is his or name.
That postal
Yes, yes.
acknowledgement.
That he has annexed that.
So it seems this acknowledgement has come by registered post. This is the acknowledgement on the next page.
To
Yes,
to
Your
petitioner.
Lordship. Yes, Your
Is
Lordship.
it so?
Yes, Your Lordship.
So this is of 16/8/2000.
Yes,
Yes,
Your
even that is after that. 16/8/2000.
16/8/2000 is part of this acknowledgement.
Yes, madam. She was terminated in 2001. So our case that we have stated that she did not avail that opportunity for undergoing training in 2001. If you would have undergone.
Why did you apply in 2000, August
Yes.
2000?
Because, Your Lordship, 2001 is when the petitioner was informed about the sponsorship, Your Lordship, that the department was,
Where is that?
that has not been annexed.
Then
Lordship, they also agree to that. They have also stated that it was in the year 2000,
See,
2001.
you were required to acquire your qualification by June 2001.
By June 2000.
June 2000. And you are making this application in August 2000. So after this, and have you stated anywhere that from 1998 to 2000, you could not have applied? Did you make any application?
No, Your Lordship, the department provided for the sponsorship in the year 2000, 2001 is what also is their submission and also the submission of the petitioner, Your Lordship.
Where is that? That a sponsor, your case was sponsored, where is that?
Your Lordship, it is also the submission of the opposite parties, Your Lordship.
Unless he applies, we cannot recommend. That is
No,
the.
no, what you recommended in 2000?
Unless what is the in-service training, my lord, a candidate had to apply when the prospectus is published, an in-service candidate apply through the department. Unless he applies, the department cannot recommend her. She admitted fact, as it reveals from Annexure 5 of Rejoinder, he applied in 2000. And we have also sponsored her in 2000. Even then, she did not avail that opportunity.
Like in the second half. Second half, we will just offer.
Okay, sure. Should have sponsored my name. Since the department did not sponsor, Your Lordship, at the end I applied. And it was not possible for me to acquire it from outside since I was in service, Your Lordship.
Right.
And your lordship, one more submission, your lordship. Your lordship, that condition, if that was mandatory, your lordship, instead of directory, then your lordship, I'm posing a question on myself as to how they approved my sponsorship after the expiry of 2 years, your lordship.
Because you were in service and you wanted to do BA, they allowed you to do BA.
But your lordship, if that was mandatory, then
That was not for the purpose of your retention in service. Because you were in service and you wanted to do BA, they sponsored you.
but it was not within 2 years, your lordship.
No, that is not clear from that it was because of that condition in the approval letter.
But they have the records, your lordship. They have the data.
Any teacher or any he could have applied for his case.
All the names of the teachers and their data is with them, your lordship. If I would have been relieved,
Very difficult.
if your lordship, I would have been relieved from my service, then I could have acquired the minimum qualification.
You could have not joined. You could have said that let me grant me leave. You were knowing.
Your
All right.
lordship, the 2 years requirement is not mandatory, your lordship. There are cases also, your lordship, wherein that time has also been
We admire your perseverance.
obliged, your lordship. If your lordship may only consider
Yes.
the case law that I have relied upon, your lordship, Vivekananda's case, and that my case also is squarely covered by that case law.
We
your
will note that. We will notice. The petitioner in the present writ application filed under Article 226 of the Constitution of India has put to challenge. Where is the tribunal's order? You have challenged that order, no?
Yes, your lordship. Annexure 7.
Put to challenge. Order dated 27/1/2012, passed by Odisha Administrative Tribunal, Cuttack Bench, whereby his original application has been dismissed. Original application, that is OA number so and so. What is OA number? OA number 1759 bracketed C 2000. And what is the other OA number?
There are two OAs, your lordship. This was a common order. First OA, the approval order was challenged. Second, the termination order was challenged.
And OA number 3410
Yes, your lordship.
bracketed C of 2002.
Yes, your lordship.
Para 2, para 3, description, both cases, why they are like. Para 2, para
The facts, certain facts, please take us. Are not in dispute, deserve to be taken note of at the outset. The petitioner had joined as an assistant teacher in Jandol High School, in the district of Sambalpur on 13/10/1990. The
said school was taken over by the state government.
Yes.
By the state government with effect from 7/6/1994 by way of a resolution dated 16/4/1994.
16/12/1990.
16/12/1994. Stop. Later, on 29/7/1995. 29/7 or 17?
29/7.
29/7/1995. The government is said to have approved a post of additional section teacher in the said school. So from the petitioner's appointment in the said school was approved by where is the document approval?
By order dated 12/6/1998.
No, no, where is that?
Approval, my lord. At page 11 of my counter.
Was approved by approved with the issuance of an office order number 8506 dated 12/6/1998 by the Inspector of Schools, Sambalpur Circle. Top. It was specifically stipulated in the said office order dated 12/6/1998 that the persons whose services were being approved must acquire B.Ed training within 2 years from the issuance of the said office order, failing which the approval shall stand cancelled automatically. Full stop. Acting upon the said office order dated 12/6/1998, the petitioner petitioner functioned as additional section teacher.
the petitioner had approached, the Central Administrative Tribunal.
Odisha Administrative Tribunal. Odisha Administrative Tribunal.
Oh, sorry, what did I say?
State Administrative Tribunal.
State Administrative.
Odisha Administrative Tribunal by making an application registered as OA number 1759 bracketed C/2000 seeking a relief for exempting the application, seeking a relief to exempt the exempt the petitioner from the requirement of passing B.Ed examination within 2 years and to allow him 1 more year to pass the said examination. Full stop. Later, do you want to say something? No. Later, comma, by an order dated 19th or 9th?
9/3, Your Lordship.
9/3/2001. The service of the petitioner was directed to be terminated pending final decision in OA number 1759 bracketed C/2000 before Odisha Administrative Tribunal. Stop. Questioning the legality of the said order dated 9/3/2001, the petitioner filed another original application before the tribunal, giving rise to OA number 3410 bracketed C of 2002. So stop. This is how the said 2 original applications have been decided by the Odisha Administrative Tribunal by the order which is impugned in the present proceeding. Stop. Learned counsel appearing on behalf of the petitioner assailing the impugned order has firstly submitted that when the petitioner was appointed on 13/10/1990, before taking over of the school, there was no requirement of B.Ed qualification for appointment as an assistant teacher. He secondly contains that the petitioner's appointment as assistant teacher, as additional section teacher, cannot be said to be invalid in the absence of B.Ed qualification and absence of B.Ed qualification may have the only can have the only consequence that the petitioner would not be entitled to trained scale of a trained teacher. Scale admissible to a trained teacher. So he has placed heavy reliance on a coordinate bench decision of this court in case of Vivekanand Das versus State of Odisha and others. Is it not reported? Reported in Manu/OR/0325. It's there.
No,
It is reported.
it was 2002, bracket 1.
2002 bracketed 1 OLR 243 with special reference to paragraph 5 thereof, which reads thus. First off, he has secondly submitted that since the petitioner was not given an opportunity to pursue the teachers training course while in service, the petitioner could not obtain B.Ed qualification. First off, at the first opportunity available to the petitioner, he had applied in 2000. And later, the state government had approved, or who had approved?
State government, SCRT is to approve, madam.
The SCRT.
To sponsor.
And later, the appropriate authorities had sponsored the petitioner's candidature to do his B.Ed course. First off, she accordingly contains that the petitioner could not be blamed for not acquiring B.Ed qualification within 2 years from the date the petitioner's appointment was approved. Anything else? Stop. Next. Okay. It has been disposed of. Waiting on. So, there was Mr. and so learned AGA appearing on behalf of the opposite parties has submitted that the approval of the petitioner's appointment against the post of additional section teacher was conditional subject to him acquiring B.Ed qualification within 2 years of issuance of the office order. So, he has submitted that once the petitioner failed to acquire B.Ed qualification within the stipulated period he cannot the order of termination, in view of termination. So he has further argued that there is no material to suggest that the petitioner had taken any step for acquiring B.Ed qualification before 2000. And therefore, before 2000, and therefore, the petitioner himself is not is responsible for not acquiring B.Ed qualification within stipulated time. Anything else?
No. I have just relied upon one judgment that I have given that judgment. Because she has relied upon that Vivekanand Das case, I have relied upon one judgment 1992 LR 185. That Vivekanand Das
Manmohan
judgment,
Tripathi.
yes, that has been taken note of that case.
He has placed reliance on division bench decision in case of Manmohan Tripathi versus State of Odisha, reported in 1999, Volume 2, OLR 185.
Well,
which paragraph?
But that has been dealt in para 11 and 12. Ten, 11, 12.
What is there?
May I give that book, my lord?
No, it is there. Judgment is here.
My lord.
Next. After having heard learned counsel for the petitioner and learned AGA for the State of Odisha and perused the pleadings and other materials of record, we are satisfied that the approval of petitioner's appointment as additional section teacher by the office order dated 12/6/1998 was conditional, subject to the petitioner acquiring B.Ed qualification within 2 years. So stop. It was clearly mentioned in the office order that in case the petitioner failed to acquire the said qualification, the order of approval shall stand cancelled automatically. So stop. The petitioner has not been able to show whether he had made any effort to obtain to pursue B.Ed course by seeking permission from the competent authority so as to fulfill the condition of approval, comma, before 2000. So stop. When counsel for the petitioner has attempted to convince this court that the very fact that the petitioner's candidature was sponsored for pursuing B.Ed course in SCERT, SCERT suggests that the petitioner had made efforts, and because of the failure on the part of the opposite parties to sponsor his candidature, comma, he could not pursue B.Ed course. So stop. This said submission does not convince us for the reason that neither there is any material on record nor any pleading that to the effect that the petitioner had taken steps for pursuing B.Ed course reasonably after within reasonable period after approval of his appointment in 12 appointment on 12/6/1998. So stop. In our considered view, the decision in case of Vivekananda Supra is distinguishable on facts. In that case, he had acquired qualification, B.Ed qualification. In Vivekananda's, he had acquired.
No, Your Lordship. He had not acquired, Your Lordship.
Last 6 lines. The decision in the last case.
In that case. Manmohan Tripathi.
This can be set to have later in a population of the nominee of the school must be now considered the decision to remove the crime. This will on facts.
On facts. What is the distinguishing fact, Mr.?
That election that I am showing my lord, that what is the standard stepping pattern, but that has not been taken into account in that Vivekananda Das case. That standard stepping pattern of the year 1981, which speaks that
The decision in case of Vivekananda has been considered by the division bench in case of Manmohan Tripathi Supra
wherein it has been observed in paragraph 10.
Your Lordship, paragraph 8 last.
We cannot see anything.
My lord, I am giving my book, my lord.
Yes, according to standard pattern.
Your Lordship,
Besides the school.
yes, my lord. Your Lordship, you can get it from para 8 last line. The situation changed with
No, your
instruction.
this para is different.
Yes.
The decision in Vivekananda
Yes, ma'am.
case cannot be said to have laid down any proposition.
Yes.
Thereafter, 11.
The relevant portion of paragraph 10. Reads as under for the decision in case of last sector series. In paragraph 12, in case of further, in case of Manmohan Tripathi, the division bench held in paragraph 12 as under. Full stop. As in case of Manmohan Tripathi, the petitioner was given an opportunity to obtain B.Ed qualification while approving his appointment by order dated 12/6/1998. Stop. Next. In such view of the matter, in the impugned order passed by Orissa Administrative Tribunal, this writ petition stands dismissed accordingly, being devoid of merit. Yes, madam.
Pleasure.
Item 57.
Yesterday, my lords. Yesterday, my lords, I refer to the provisions in NSM Act in section 18. My lords, you have a glance to that section once again for better appreciation.
Yes.
Minutes, section 18.
Yes, section 18.
Section 18 minutes, subsection 1 permitted the concerned party to make a reference.
Yes,
For-
we have.
make a reference for conciliation. Then subsection 2, may I read it, my lords? On receipt of the reference under subsection 1, the council shall either itself conduct the conciliation in the matter or seek the assistance of any institution or center providing alternative dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provision of section 65 to 81 of the Arbitration and Conciliation Act 1996 shall apply to such a dispute as if the conciliation was initiated under Part 3 of that Act.
Yes.
There, my lords, I am posing myself for a moment, my lords, to bring my lords notice about the provisions under section 65 to 81. I think my lords put two very important pertinent questions there. That particular section is there itself in the Arbitration and Conciliation Act. But that is what, my lords, I am referring to the section 65 to 81 of the Arbitration and Conciliation Act. That is part 3 of the Arbitration and Conciliation Act. Section 61, it is part 3 of the Arbitration and Conciliation Act. Starts from section 61. May I say, page 93.
Yes.
How the conciliation is being taken up, probably this is the procedure, my lords. This procedure is adapted to that MSME Act, section 18(2). Application and scope, that is not pertinent now. Commencement of the conciliation proceeding. The party intending conciliation shall send to the other party a written invitation to conciliate to the conciliator. Under this part, briefly identify the subject of the dispute. Then, my lord, the provisions about the particulars. Number of conciliator is not relevant in the present case. Appointment of conciliator is also not relevant. Then, my lord, very important is 65. The conciliator, upon his appointment, may request each party to submit to him a brief written statement describing the general nature of the dispute, the point of issue. Every party shall send a copy of such statement to the other party. The conciliator may request each party to submit to him a further written statement of each position and the facts and the grounds in support thereof, supplementary to any document and other evidences that such party deems appropriate. The party shall send a copy of such statement, document, and other evidences to the other party. Then, third stage, at any stage of the conciliation proceeding, the conciliator may request a party to submit to him such additional information as may fit matters. Then, matters the conciliation that is not relevant now. Then disclosure of information 70. Disclosure of the information. May I pray straightway to consider section 76, termination of the conciliation proceeding.
That is the
termination of the conciliation proceeding. These are the 4 stages, but 4 contingencies. In one case, the conciliator can do. In other case, both parties may agree. In third case, one party may also write to terminate the conciliation. Then, my lord, the very important thing is that what my lord says, my lords, 80. Last week, my lord put this question. Of course, my lord, that has been also dealt with, and the Honorable Supreme Court in number of decisions said that yes, this is a statutory provision. So the council may continue with the arbitration, even if it deals with the conciliation. But the section 80 clearly bars that.
yes.
Then 81. Admissibility of evidence in other proceedings. The parties shall not rely on or introduce as evidence in arbitral or judicial proceedings, whether or not such proceedings related to dispute that is subject of the conciliation proceedings. Views expressed, suggestions made, then admission made, then proposal made, then the fact that other party had indicated his willingness to accept a proposal for settlement made by the conciliar. My humble contention, my lords, 18.3 should be read in conjunct with this. Conceptualize is one thing. Conciliation proceeding, suppose my lords, I file a petition before the council. This is taken under 18.1. Then 18.2, the conciliation process goes. During conciliation process, the parties will be required to file their counter. Other party may be required to file their rejoinder and documents. Thereafter, if conciliation fails, those pleadings, those contentions, those grounds stated, those disclosures doesn't stand in the way, but that cannot be utilized in an arbitration proceeding to be commenced thereafter. What's very important is that, manners.
Mr. Your seat anchor, it should be section 76.
76 and 81.
Which says conciliation proceedings shall be terminated by signing, by written declaration, by written declaration, by written
declaration. Then, manners, 81, if conciliation fails, then, manners, those evidences or those pleadings, whatever we given in during conciliation process, we cannot utilize it. That is 81. In an arbitration proceeding, may read it, manners. The parties shall not rely on or introduce such evidence in arbitral or judicial proceedings. So it conceptualizes that conciliation is a separate process, arbitration is a separate process.
No, that conceptualizes, there is no doubt.
But here, my lords, what happened so far fact is concerned. Three important facts, my lords. Three important dates, my lords. Thing is that the conciliation process continued. Maybe for a pretty long time, I don't dispute. The conciliation process, my lords, I'm referring to.
Mr. The only thing is that according to you, the conciliation proceeding had not ended. The conciliation proceeding had not terminated.
Yes.
And without termination of conciliation proceeding, the award has been passed.
But
This is
no, my lords. I'm on one step forward. That is what, my lords, I'm referring to page 121 once again. The order. Whole total process, my lords, show after reference a claim petition was filed, counter was filed, rejoinder was filed, all these were filed. Thereafter, conciliation failed. My humble contention, conciliation failed. That the council recorded it. But I'm reading that last portion. The council observed that so many hearings has been made on 16/11/2019 and such and date, including, the important is in which OP was absent on such and date, then 30/12/2020. This is the last date, the day this order passed. Thereafter, the council held, the petitioner submitted that the conciliation process with opposite party was terminated without any settlement as per section 18(2) of the MS-MED Act 2006. So there, I say, he has come before the conciliator because there is no settlement, it is terminated. Thereafter, the council would have commenced the arbitration proceeding. It's not that to pass an award followed by this. After the conclusion of the conciliation proceeding, award should not have been passed. What the council did is, that thereafter, the council perused the claim petition and counter statement filed by both the parties. It found that the claim of the petitioner was genuine and decided to make an award as follows. That is the award manner. That award was passed in my favor. So it constituted an award. My humble contention, I have gone through the decisions, my lords, whatever my lords referred to. None of the decisions are in connection with this aspect, except in Jharkhand case. The issue is that somebody has not appeared. Thereafter, they have come and challenged it in a writ jurisdiction. Thereafter, all these disputes have come. But Honorable Supreme Court categorically held that what is the status of if an award passed after conclusion of the conciliation without following the arbitration procedure, as required under section 18(3), that is nullity, that is non-nest in the eye of law. It's not sustainable in the eye of law. That is what I'm referring to, few of the observations. None of the judgment are referring to this aspect. This aspect has only been dealt with in that case with due humility manners. In one case, I found Honorable Single Judge of Madras High Court, very vehemently dealt with in very lucid manner and detail I dealt with, but it is a decision of Honorable Single Bench. I refer to in my written note of submission. There, I have given that. There, the Honorable Madras High Court categorically held. There was a contest. Part amount released. Then also they said, no, you have jumped into. You cannot club together. This is not a clubbing procedure. So that I have endorsed that I will rely upon these matters, but now in view of the settled position in the Supreme Court decision matters, that decision, I think that concept which has been developed there, though it is in detailed terms, but has been taken care of by Honorable Supreme Court. There matters kindly have a glance to paragraph matters. Paragraph 5. This is the contention, main contention that my learned senior has given in his reference. I have also given the judgment matters to my written note of submission.
Yes.
May I read it? This is the contention. It is mainly contended by the learned counsel for the appellant, as there was some dispute on the supplies made by the third respondent. A bill amount due was not paid immediately. It is submitted that only on the ground that the appellant has not
Yes.
The appellant has not responded in the conciliation proceeding. Straightway, the order was passed by the council without giving proper opportunity. The order impugned in the writ petition was passed in utter disregard by to the mandatory provision under section 18 of the Micro, Small and Mid MSME Act matters and provisions of arbitration and conciliation 1996. It is submitted that even after the order passed by the council on 6/8/2012, the appellant, after inspection of the record, has paid a due amount of such and such. Such amount was paid after inspection of the record to the third respondent, who has received that amount without any protest. After a period of 3 years, thereafter the contingency. Thereafter, third respondent has filed an execution case before the civil judge, Ranchi, which ultimately ended in dismissal on the ground of maintainability. When the said order was challenged by the way of the writ petition, the said writ petition was subsequently dismissed as withdrawn. It is submitted that when the conciliation failed, as per section 18(3) of the MSME Act, council has to initiate arbitration proceeding. Well, that is their main submission. On failure of conciliation, the council shall either itself take up the dispute for arbitration or refer to any institution or center providing alternative dispute resolution services for such arbitration. Provision of arbitration and conciliation in 1996 shall apply to the dispute as if the arbitration was in pursuance of the arbitration agreement referred to under subsection 1 of section 7 of the Arbitration and Conciliation Act. That section says, as if an arbitration agreement is there, then section knows about the section 16, parties will be given due opportunity, claim, then a written statement, counterclaim, it will follow the procedure. They have to lay down their own procedure. This is completely separate procedure under a separate act, under Arbitration and Conciliation Act. In this case, my humble contention, why I am submitting it, nothing has been followed. Straightway he jumped into an arbitration proceeding, arbitration hour. Then, my lords, it is submitted that in case without following the procedure, straightway the order impugned in the writ petition was passed without giving any opportunity to the appellant to participate in the arbitration proceeding. It is submitted that as the said order was passed in utter disregard to the mandatory provision of Arbitration and Conciliation Act 1996, the said order is a nullity and cannot be termed as an award under the provision of the Arbitration and Conciliation 1996. It is further submitted that as per term of the contract, any dispute was subject to the jurisdiction of civil court. That is not relevant matters in this case. Thus, it is submitted that the order passed by the council is without jurisdiction and contrary to the term and condition of the agreement. Then, my lords, paragraph 7. In the writ petition, the appellant has challenged the order of award, that was 6/8/2012. Here in this case, my lords, they were absent, straightway award was passed. Here in this case, I was present, I was also absent, then the award was passed. I was also absent on that date. The observation says, I was absent on that. Award was passed. The second counsel constituted on the third respondent has approached the counsel seeking direction against the appellant for payment of the due bill, and immediately after filing application by initiating conciliation proceeding, counsel has issued notice and the appellant has not appeared. Then he quoted the notice, quoted the summon. Then paragraph 8. Only on the ground that even after receipt of the summon, the appellant has not appeared, the counsel has passed order of award on 6/8/2012 on the same day. As per section 18.18.3 of the MSCBD Act, if conciliation is not successful, the said proceeding stands terminated, and thereafter counsel is empowered to take up the dispute for arbitration on its own or refer to any other institution. Once it is concluded, then arbitration proceeding began. That is my humble submission. The said section itself makes it clear that when the arbitration is initiated, all the provision of Arbitration and Conciliation Act 1996 will apply, as if arbitration was in pursuance of an arbitration agreement referred to under subsection 1 of section 7 of the said act, means Arbitration and Conciliation Act. Then my lords have quoted section 18, referring to section 18 in para 9.
Please sit properly. Please sit properly in the courtroom.
Yeah. Para 9 minutes. Then para all four paragraphs 18.1, 18.2, 18.3, 18.4 have been quoted from the reading of section 18.2 and 18.3 of the MSCBD Act. It is clear that counsel is obliged to conduct conciliation, for which the provision of section 65 to 81 of the Arbitration and Conciliation Act 1996 would apply, as if the conciliation was initiated under part 3 of the said act. Under section 18.3, when conciliation fails and stands terminated, the dispute between the parties can be resolved by arbitration. The counsel is empowered either to take up the arbitration on its own or refer the arbitration proceeding to any institution, especially. It is open to the counsel to arbitrate and pass the award, after following the procedure under the relevant provision of the Arbitration and Conciliation of 1996, particularly section 20, 23, 24, and 25, in addition to other provisions. Here in this case, what happened? The conciliation was concluded on the day, not attend finality, means it is not attended any conclusion, then immediately award passed, without resorting to the arbitration proceeding as it is required under this. Then what my Honorable Supreme Court said, there is a fundamental difference. That is, the observation is very important. There is a fundamental difference between conciliation and the arbitration. In conciliation, the conciliator assists the party to arrive at amicable settlement in an important and independent manner, in an impartial and independent manner. In arbitration, the arbitral tribunal, arbitrator adjudicates the dispute between the parties. The claim has to be proved before the arbitrator, if necessary, by adducing evidence, even though the rule of civil procedure and Indian evidence does not apply, unless otherwise agreed, oral hearing are to be held. If the appellant had not submitted its reply at the conciliation stage or failed to appear, the facilitation counsel could at best have recorded the failure of the conciliation and proceeded to initiate the arbitration proceeding in accordance with the relevant provision of the Arbitration and Conciliation 1996. So it is initiation of the proceeding 96 to adjudicate the dispute and to make an award. Proceeding for conciliation and arbitration cannot be clocked. In this case, only on the ground that the appellant had not approached in the proceeding for conciliation on the very first day of appearance, that is on 6/8/2012, an order was passed directing appellant such and such to pay an amount of such and such towards the principal claim and odd. As it is clear from the record of the impending proceeding that the facilitation counsel did not initiate arbitration proceeding in accordance with the relevant provision of the Arbitration and Conciliation 1996. The order dated 6/8/2012, means the award, is a nullity and runs contrary not only to the provision of MSCBD Act, but also contrary to the various mandatory provision of the Arbitration and Conciliation Act 1996. The order dated 6/8/2012 is patently legal. There is no arbitral award in the eye of law. It is true that under the scheme of the Arbitration Conciliation, the arbitral award can only be quashed by way of application on 34th of the Arbitration Conciliation Act 1996. At the same time, when the order is passed without recourse to the arbitration and in utter disregard to the provision of Arbitration and Conciliation Act 1996, Section 34 of the said Act will not apply. So my humble contention, my lords, I cannot resort to Section 34, cannot apply. We can reject this appeal only on the ground that we cannot reject the appeal only on the ground that the appellant has not availed the remedy under Section 34 of the Arbitration and Conciliation of 1996. The submission of the learned senior counsel appearing for third party respondent that there was a delay and laches in filing the writ petition is also not accepted. Well, then thereafter, Honorable Supreme Court observed relating to some other issues that ultimately remanded the matter. Ultimately remanded the matter for fresh adjudication. Here in this case, what has happened, my lord? We, after conclusion of the conciliation, award was straightway passed on the same day. My lords, referring to the pleadings made in during conciliation, then, my lords, I was required to file at 34. I resorted to the provision of, because I say this is a nullity. That is what I have come before the Honorable Court. Now, my lords, I am referring to two of the important information. So that is, my lords, I have filed a, so far writ appeal is concerned, I filed a petition there. Now, after the order passed, what is the stage and what is the process going on? Manners, in this case, I enclose the after this order passed by the Honorable single bench, what the council observed. Page, that is my reply in IA number 82 of 2023 to the writ appeal. I enclose that order.
You have filed a rejoinder?
I filed a I enclosed it that in IA number 82.
Not there.
82 of 2023 minutes.
82.
Filed on 9/1/2023 minutes.
82. IA number 82. 82 of 2023.
Minutes. Referring to all dotted minutes.
Yes.
That is an annexer, annexer B. Annexer B. Order dated 7/7/2022. There, my lords, this matter was referred to
218. 218.
Got it, man?
Yeah, please.
Straightway, the learned our council, they dealt with the detail of sequence. Then referring to this detail particulars, at page 20, internal page 24, observed as follows. Taking cognizance of the fact that the award was passed at the stage of conciliation process under Section 18(2) of the MSMED Act, the council initiates arbitration proceedings under Section 18(3) of MSMED Act between the erring parties. So this proceeding has already commenced. We filed our counterclaim and written statement because of the minors, but thing is that now it is under challenge before the Honorable Division Bench. Well, that is what the proceeding is not, it's not continuing, and that is just stalemate position. My humble contention, matters referring to all these things, the thing is that there, the act makes it very clear.
No, you are not required to repeat that.
No. Just to concept, that's to just preach the thing, to pinpoint the things. Here in this case, my lords, the law is well settled. A act prescribed a thing to be done in a particular manner should be done in that manner only. My lords, in this case, Section 18 has prescribed the procedures, prescribed, my lords, the stages when the arbitration proceeding will commence, and also prescribed the authority who is to deal with the arbitration proceeding. In such a contingency, the arbitration proceeding to be commenced and the parties should participate. Thereafter, an award may be passed in consonance with Section 18. Then only, if the award passed, then we are bound to challenge it under Section 19, resorting to 34. My lords knows the difference between the 34, I need not repeat it. Under Section 34, suppose somebody files a petition.
Sir, we have understood your submission. It's like you will go on repeating the same.
No, my lord, I'm not, my lord, only for the purpose of payments, my lords.
At least we have some experience. We can understand.
Not some, my lords, it's a vast experience, my lords.
Not much, but yes.
It's a vast experience, my lords. Only thing is that 34, there is no limit. 10%, 20%, 30%. That depends upon the court's discretion. Here, 75% specified. My humble contention is that no award is in the eye of law.
Yes, Mr. Mishra, he appears to be right in his submission.
So it appears to sounds very authentic, but I have got an answer to that.
Yeah.
First thing, Your Lordship asked me one question where Your Lordship concluded the argument part yesterday, that whether there is any other order that the conciliation has terminated.
No, we wanted to know the date when the conciliation had terminated.
Right. But let me be very candid in my confusion that except the impugned order, no order is available with me. First thing.
Yes.
The petitioner challenged the award. The order passed. If Your Lordship looks at the writ application, two grounds of challenge. First thing, one arbitration case is going on. Therefore, this proceeding is.
No, we will not. We will not go into that aspect.
No, that exactly. I would say that has been concluded actually.
The question is.
Yes.
That some award has been passed. That award is being treated to be an award under the provisions of the Arbitration Conciliation Act.
Right.
That award can be challenged according to you under Section 34.
Read with Section 19.
The question is whether that is an award or not.
Yes, absolutely correct, my lord. I am just explaining that, my lord. If Your Lordship looks at the conciliation proceeding, which is to be followed, starts from Section 65 to 81 of the Arbitration Act. Chapter 3, Section 65 to 81, not otherwise. But in the instant case, no order has been filed for Your Lordship except this order, that the conciliation proceeding has not started or it has not been concluded before. A person who challenges that on that ground has to file the entire order sheet of the tribunal to show that from the day one till the day the final order was passed, conciliation proceeding has not terminated. This is number one. He has not filed. Second thing is, in conciliation proceeding, there is no question of calling for counter and rejoinder.
No, this is what the procedure lays down.
So it's not counter rejoinder.
Oh, yes. Maybe counter rejoinder is a misnomer, but
submissions.
Only
but here the submissions were filed before. The counter means dispute. Submission means respective cases. The case of the petitioner.
The question is different. Mr.
Right.
The question is that there are stages. One stage is conciliation.
Correct.
The conciliation must terminate before the arbitration begins.
Absolutely correct.
So where is that termination?
So that termination he has to justify.
No, you will
in
have
my
to-
case.
See, you are, this is the reasoning assigned by the learned single
Right.
judge, that the council jumped to passing of an award without entering into the thing.
In fact, if Your Lordship will kindly see, one thing was submitted, he was absent on the day. He was very much present on the day when the.
So presence absence, we are
Right.
we are not on those small things. We are on the question as to whether any arbitration proceeding was held at all or not. That is the
But
question.
my respectful submission is that this order has been passed on date of hearing of the arbitration proceeding.
How do you?
This order,
All right.
my lord, with due respect, my lord, what I feel, my lord, on the,
If we accept your submission.
Right.
And this was asked in an arbitration proceeding.
yes,
Then what happened to the conciliation proceeding?
it has been terminated.
Where? Where there the conciliation?
Sir, actually, if your lordship looks at the first paragraph itself, kindly have a look at the order itself, impugned order. Impugned order is, if your lordship looks at, to adjudicate the claim and date of hearing is this.
So everything is incorrect. Right from the very beginning, each and every sentence is incorrect, unless if it is an arbitration proceeding, then there must be something that the conciliation had failed. And the conciliation cannot fail just
So during the process, during the process of adjudication, with due respect,
no question of adjudication.
when it discuss the entire thing.
Before adjudication, Mr. Mishra, conciliation must conclude.
Yes.
And conciliation must terminate. And conciliation must terminate in the manner as provided under section
74.
Sorry, 76.
74 of the Arbitration Act.
74. No, 76.
76, I'm sorry.
76.
76.
So 76.
Kindly say D. D, my lord.
Yes.
By a written declaration of a party to the other party and the conciliator, if appointed, to the effect that conciliation proceeding had terminated on the date of declaration.
So therefore, there has to be some writing on a sheet of paper that by settlement agreement, A, by written declaration of the conciliator, 2, a written declaration of the parties, 3, a written declaration of a party to other party, 4. So there must be something written.
Sir, here the information of the party has been recorded that it has already been done. But may I just pray one thing, my lord? If you kindly see, my appreciation with regard to the order is, as if it's an arbitration of order itself, but after the conciliation has terminated. But it can only be verified from the record which is available with the government. Or they are the government party, my lord. Government is also a party here. The conciliators are usually a party here. But if your lordship call for the record for verification.
No, why? This is your case. You can say. You are participating throughout.
Yes,
he might be absent. But can you
No,
say
he was not absent. He was present.
Even if he was present, can you say that this is the date when the order was passed under section or something was there under section 76? Or if unless there is an evidence that the conciliation terminated in accordance with section 76 of the Arbitration and Conciliation Act, arbitration proceeding cannot be said to have started.
Sir, with due respect, unless I get the copy of the order, I cannot offhand tell your lordship whether it is comments or not. But to my understanding of the order itself.
The difficulty is that in the what you are calling award, in that order, the council has written everything, history, from the beginning, but it has not recorded as to when the conciliation had terminated.
The date has not been mentioned, but mention is that the petitioner has informed about the termination. It is mentioned that petitioner has informed about the termination of the conciliation. That sentence is there. If your lordship kindly see, I think your lordship must have seen that before the ordering portion, if your lordship kindly see, the petitioner submitted that conciliation proceeding with the opposite party was terminated without any settlement on section 18(2) of the MSME Act. So this statement itself shows there has been a termination.
Shows what? Please read it again.
The petitioner submitted that conciliation process with the opposite party was terminated without any settlement as per section 18 of the MSME Act. That means he informs that termination, conciliation proceeding has already been terminated. This itself shows there has been a termination of the proceeding.
Who was the petitioner?
Beg your pardon, madam?
Who was the petitioner?
Petitioner was, myself was the petitioner.
Then you are to say, you are to tell, you are to inform us that see, this is how it has terminated. You had informed.
I had informed it has terminated.
Has been recorded. it has been recorded in that order. And the petitioner had informed the council
Right.
that it terminated. So you could terminate by informing the other side.
It has been informed, not.
No, but where is that? You could say that on this date I had informed that conciliation proceeding stands terminated.
That I have to check about. The reason being, if Lordship kindly see.
He appears that Supreme Court's decision, and he is right in his submission that after beginning of arbitration proceeding, everything should have been followed, every provision under the Arbitration and Conciliation Act, like parties may require to lead evidence or whatever, nothing more than.
But with due respect, my lord, the persons who man the chair for the purpose of the adjudication of the dispute, like the Consolidation Commissioner or anybody else, my lord, they are all officers not equipped to the judicial process.
We understand. We understand.
Not judicial process, my lord.
We understand.
That has also been taken note of in several decisions, my lord.
We understand.
But they usually follow the manner of writing is something different than the manner of writing of a judicial officer or a High Court judge or a Supreme Court judge, my lord. But this writing is of their own way they write. But therefore, we cannot find fault with that, saying that you have not followed that procedure or this procedure, but they have discussed everything with regard to the merit.
They can discuss,
Right.
suppose they might have discussed everything for the purpose of reaching a conclusion as to whether the conciliation proceeding fails or succeeds.
Or what I understand from the order itself, from the beginning when the hearing started, they were present. They never objected that this is not hearing of the arbitration, this is conciliation. But even assuming, because it was in their presence, everything has been done. It is not there. Supposing we are hearing the matter for final disposal.
Now take it from a different perspective. A proceeding is continuing. The proceeding is under for conciliation. So the parties may be of the view that it's the conciliation proceeding, and even if they consider it to be arbitration proceeding, they think that it may be arbitration proceeding, but they may plan that let it go. We shall challenge if any award is passed.
That is exactly bad.
That can happen.
You're absolutely correct.
We have to.
They should have raised something. So now, sir, now the conciliation failed, kindly proceed with the arbitration. They never raised any objection to that effect. They were present on the day itself.
The difficulty.
But if they are present, they should have raised objection. They cannot now turn around and say that we will wait until we challenge the same before the High Court ballot. Because at the time when the award was passed, this judgment has not come. With due respect, my lord. Judgment says you cannot challenge.
No, judgment had not come, but the law was there.
Law is there. Right. I fairly concede to that extent. But my humble submission is that, but when one participates in the hearing, but here the counter, rejoinder, everything has been filed after failure of conciliation. With due
After
respect.
failure, it's very difficult. It is very difficult to.
But one thing I would like to say, the basis on which a party challenges this order, he says that the conciliation proceeding ended and then award has been passed. Am I clear, my lord? He has to prove that this is a process of conciliation proceeding. No material is there for lordship to say, hold, that this is not an arbitration hearing, but it's a conciliation proceeding. The reason being, this is not that court concluded the conciliation terminated, now I'm passing the award. Court has not proceeded to hold on the conclusion the conciliation failed and I'm passing an award. Court has heard it on the merit. He should prove that this is a conciliation process. Conciliation process not started prior to that. This has not been established.
So let it be established then. Let the records come.
The record, I think the record should be produced, madam.
All right. So you produce the records?
No, he is not. The government is to produce.
Yes. The council is a party.
This government is there.
Council will produce. I'll get the records from the council.
Tomorrow or day after?
Day after two. Let me, because copy has not been served on us.
No, no, read copy must have been served. No, read, you are a party.
Appeal, in appeal.
This is Office of Director of Industries.
Okay, then we can get.
Micro and Small Enterprises Facilitation Council represented through its Chairman and Director of Industries.
And then we can.
Office of Director of Industries behind.
Yes, Lords may keep it to day after tomorrow.
A controversy has arisen.
Absolutely.
During the course of hearing of the present writ appeal on the question as to whether the conciliation proceeding initiated by virtue of subsection 2 of section 18 has
Section 76
terminated in accordance with the statutory requirement under section 76 of the Arbitration and Conciliation Act 1996 or not in the proceeding before which is the proceeding before which council is this?
Micro and Small Enterprises Facilitation Council.
Okay. My read petition minutes are very good. Stated clear. My read petition are stated clear.
From your petition on.
That is Micro and Small Enterprises Facilitation Council represented the Chairman and Director of Industries.
This is what that learned AGA produced the original records of what is the number?
MFS number pertaining to
MSEFC case number 51 of 2019.
51 of 2019.
MS
51 of 2019.
Yes.
On day after tomorrow, 2 p.m. 2 p.m.
Day after tomorrow, 2 p.m.
2 p.m. Friday. Monday.
Disposed of on 31st of
Disposed of on 30/12/2023. 20.
Copy of this order. I need a
Yes.
copy.
Well, high replacement.
Earlier, this MSME office used to be in station.
Near Killa.
No, station road.
Hilkhana, that is just stadium.
MSME office was used to be there.
That is being dealt with. This Director of Industry is sitting near stadium, that Hilkhana. Behind Barbat Stadium. But Chilkhana. I can get it, but to facilitate it, I need the order copy.
So you will get it.
Yes.
You will get it either today. In the
Today
night.
itself.
You should get it today.
Yes.
Item 35.
Your Lordship, Honorable Senior Counsel, Mr. J.R. Dora. Your Lordship, on last occasion, Your Lordship was pleased to hear the matter of merits, Your Lordship. While hearing Your Lordship, the petitioner relied on Annexure 7, and Your Lordship directed to file a legible copy of Annexure 7, Your Lordship. Your Lordship, an legible copy is already there in the written notes, but since it has been handwritten, Your Lordship, I am submitting a, Your Lordship, a typed copy, Your Lordship, in form of reply affidavit to the affidavit, Your Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, kindly have a glance at the written notice of argument on behalf of the petitioner, Your Lordship. I'm placing that.
Yes.
Your Lordship. Your Lordship, 1978, the Arbitration Tribunal was created under the Irrigation and Power Department of Government of Odisha without giving any definite status, and the office was functioning under the INP department. The INP department has now been merged with the Water Resource Department. Your Lordship. In 1978, one post of LD assistant, lower division assistant, and other posts were created. In 8/1/1980, Your Lordship, at Annexure 1, page 11, the District Employment Exchange was asked to sponsor the name of suitable candidates for the said post of LD assistant. Accordingly, on 24/1/1980, Annexure 2, Your Lordship, the Employment Exchange sponsored the name of 17 candidates. The name of the petitioner finds place at Annexure Serial 1, Your Lordship, in that. Page 12. In the meantime, Your Lordship, during the time when the District Employment Exchange was asked to sponsor the name, and at the time when the Employment Exchange had sponsored the name, the Chairman Arbitration Tribunal was declared as the head of department, Your Lordship, on 19 January 1980, Your Lordship. Your Lordship, petitioner appeared in the written test, and as per petitioner was selected on the basis of written test and interview for the single post of LD assistant, Your Lordship, on 4/2/1980. After 6 years of service, Your Lordship, petitioner services was regularized. That is where the Annexure 7 comes into play, Your Lordship. Kindly see Annexure 7, that is the affidavit, Annexure B, page 20 of the affidavit, Your Lordship. May I read, Your Lordship? Your Lordship. Your Lordship, I am to say that the Office of the Arbitration Tribunal was created under INP department in 1978 without giving any definite status. The office has been functioning under the administrative control of INP department. The Chairman Arbitration Tribunal Bhubaneswar was declared as head of department in respect of establishment of the Arbitration Tribunal with effect from 19/1/1980. Your Lordship, by government in IP department letter so and so. One post of LD assistant along with some other posts were created as per GO number 36652 dated 2/11/1978, and the post was filled up by a direct recruitment in February 1980. Sri Jamin Mohan Mohanty, the petitioner, a candidate sponsored by the Employment Exchange Bhubaneswar, was selected and appointed as LD assistant in the office order so and so, who joined on his duty on 29/2/1980. Although passing through recruitment examination prescribed in the OMS rule 1963 is a sine qua non for recruitment to the post of LD assistant, now junior assistant in the head of department, this fact was unfortunately overlooked. In the appointment order, this mandatory requirement should have been mentioned as the prime consideration for his continuance and retention, and failure on his attempt to pass the requirement examination would have rendered forfeit his service in this office. It appears that this office was in infancy and the codal provision of recruitment rules have been lost sight of, which is a mistake. Sri Mohanty, junior assistant, is continuing as such in the office till now, and at this stage, he cannot be asked to pass the prescribed recruitment test as he is already over age, his date of birth being 27/9/1955. It is therefore requested that the government in Irrigation Power Department may kindly consider the peculiarities of this case of Sri Mohanty, junior assistant, and regularize the service from the date of joining and communicate the orders at an early stage. On the basis of this letter, Your Lordship, as per Annex 3, page 14, the services of the petitioner were regularized.
Your service was regularized after opposite party number 3 was appointed on regular basis.
Your Lordship. Your Lordship, in that regard, Your Lordship, submitting the OMS rule. The OMS rule says,
And your regularization was not in accordance with any provision.
Your Lordship, provision was there. Relaxing rule 14, Your Lordship.
Relaxing is different.
Your Lordship, I'm placing, Your Lordship. Kindly.
And that relaxing was, that was subsequent.
Your Lordship, the rule permits regularization and that too from the date of appointment.
Yes, but he was regularly appointed before you.
Your Lordship, kindly see page 7 of the rule given, page 7, that is Orissa Ministerial Services, regulation of recruitment and conditional service of irregular recruits in the office of head of department.
Yeah.
Your Lordship, rule 3, page 7, rule 3, validation and regulation of irregular recruitment.
Yes.
Notwithstanding anything contained in the recruitment rules, but subject to the other provisions of the rules, an irregular recruit shall be deemed to have been validly and regularly recruited and appointed as assistant or clerk as the case may be.
Yes.
Then comes the seniority, Your Lordship. Page 4. Seniority of regularly recruited LD assistants in the office of head of department. Petitioner was a LD assistant, Your Lordship. The seniority of an irregularly recruited lower division assistant in the office of head of department shall be determined according to the provisions of section 2 and 4. The position of an irregularly recruited lower division assistant shall be immediately below the lower division assistant recruited on Rule 16 during the same year, Your Lordship. Petitioner was appointed way earlier, in 1980. If the date of joining is same in respect of 2 or more irregular recruits, the inter seniority shall be determined in accordance with the position given to them in order of selection. I humbly submit, Your Lordship, petitioner was appointed in 1980. After 4 years, opposite part number 3 was recruited. And petitioner service was regularized as per the OMS rule, relaxing rule 14, as per rule 14, that is at page 4, Your Lordship. Rule 14 permits relaxation, that examination was relaxed. Since he had already appeared in a written test interview, though not the written test as per the rule, but he has appeared. And he also fulfills the eligibility criteria. Eligibility criteria requires +2, Your Lordship, is a BA candidate. After that, Your Lordship, kindly see. Lordship, on a mere representation of the opposite part number 3, after 14 years, after 26 years of regulation and 14 years of promotion, without giving any opportunity, petitioner's position was reverted to the rank of LD assistant. Petitioner was promoted from LD assistant to junior assistant, and then from junior assistant to SO, Your Lordship, section officer. After working for 26 years.
Oh, he is appearing for the other side.
I am for the state.
And what about him?
Your Lordship may see that rule 13. My learned
No. What about the private party, private opposite party? Whether he is appearing or not?
Note.
There are 3 in numbers.
Someone has appeared. Notice is
3, 4, 5.
5.
3, 4, 5.
3, 4, 5. OP3 is the one who was
OP 3 to 5.
Notices were issued in 2014.
You'll also kindly see page 16, annexure 5, the order of reversion.
And before that, my lord may see that rule. My learned friend has that relied upon that rule.
No, we will come to that. Let us certain the position of service of notice. Whether someone had appeared.
No one has appeared.
Who is opposite party number 6?
Opposite party number 6 is registered Orissa. Let's say he's not necessary party, man.
That's not.
That's not formal party that we can also appear for. But
OP3 is not the party. OP3 is not.
Right. रूल का देखिए भूल देखिए चेंज करा रूल এটা রুল
What is this? Why have we mentioned this, that whether he was in service on 23/3/2009 or not?
Your Lordship, as regards to area salary, Your Lordship, for that period. Since the order of reversion, as there was no post of LD assistant available, his services were terminated, Your Lordship. Without giving any opportunity of hearing, first and foremost, the order was passed without following the principle of natural justice. After that, from the date of order passing of the order till his retirement, petitioner remained out of service.
From?
Your Lordship, from 24 March 2009 till.
So have you challenged that order also?
Your Lordship.
Did you challenge the order of termination?
Your Lordship, no, there is no formal order of termination. The order of reversion is there. But since in the reversion order itself, they have stated. Kindly see page 18.
No, please come to why did we pass this order as to whether he was in service or not as on 23/3/2009?
Your Lordship.
So what is the relevance of that?
24/3/2009, Your Lordship. On 24/3/2009, petitioner was reverted back. Till 23 to March 2009, petitioner was in service. Petitioner was working as a section officer.
Where?
Lordship, petitioner.
Please see, this is the, all right.
Petitioner was working, Your Lordship, on the basis of a representation of OP3, the order of reversion was passed, effective on that date.
Yes. Yes, whether this order has been complied with?
Yes, ma'am.
29/2/2024?
No, Your Lordship, petitioner not received pension till date, Your Lordship.
On last occasion, I have submitted my lord, he has paid provisional pension regularly after the first order of this honorable court. Thereafter, I have filed an affidavit. Your Lordship may see my affidavit. I have filed it on 12/4/2024.
Yes, we have dealt with every aspect.
Last opinion, Your Lordship, will please to hear the matter on merits again, Your Lordship.
Yes, my lord. For that reason, Your Lordship has last occasion, Your Lordship wanted to hear this matter on merit.
So please come to paragraph 7 of the last order. Why should we beat the bush? Please confine to this.
Your Lordship, on last occasion, I had placed this order only, Your Lordship. But
Come to page paragraph 7.
Your Lordship, on last occasion, this order was I was placing, Your Lordship. But Your Lordship, be pleased to hear the matter on merits again on the request of State
Please
Council.
come to paragraph 7.
Your Lordship. Your Lordship.
Please read it.
After some arguments, the learned counsel appearing on behalf of the petitioner has confined his submission to the petitioner's claim for full salary from the date when he was relieved from the arbitration tribunal till he attained the age of superannuation on 30/9/2013 and the post-retirement benefits. It had been argued on behalf of the petitioner that the petitioner, having been relieved from the arbitration tribunal, was given one posting 1 month before the due date of his retirement and post-retirement benefits. Your Lordship.
So we should confine our
Yes, Your Lordship.
dispute to this also.
In this regard, that period, that from date of his reversion till 30/9/2013, that period has to be treated as SO or as junior assistant. That has to be considered. Since petitioner was appointed way earlier than the opposite party number 3, even though petitioner has not rendered service because of the reversion order, but that reversion order is illegal, Your Lordship.
No, you cannot be paid that salary. If you want to pursue that matter, then we will hear it later after 10 years.
But Your Lordship, petitioner service was illegally reverted after
Mr. Counsel, on the last date, you confined your relief to this, which has been recorded in paragraph 7. We had forgotten. So we have to see this. Otherwise, the matter, maybe we may remand the matter back again. And that is the reason. Paragraph 11, we have recorded. And para 10.
Pension papers I have already submitted as
Yes.
per the last page drawn. In the reply also I have given that except form F, all documents.
Please come to paragraph 11.
Your Lordship.
The efforts which were made by the High Court. We are conscious of the fact. Please read it.
We are conscious of the fact that petitioner and present petition are seeking an order passed by OIT. However, we are making an attempt to get the issue resolved by passing the order of present nature for the reason that the matter has remained pending before the Honorable Court for nearly 10 years. In such circumstances, it will be, in the court's opinion, unjust to relegate the petitioner to any other forum to claim his post-retirement benefits and other dues. Your Lordship, that is there. On last.
This is the gesture shown by the court, and this is what you are doing.
Your Lordship, on last occasion, on the request of State Council, Your Lordship, are pleased to hear the matter again, Your Lordship, on merits.
Your Lordship, my lords, attempt to resolve the issue as soon as possible. Not to linger the issue.
And then we are ready to decide. Whatever you submit. Yes. Then we are recalling that order.
Your Lordship.
Learned counsel appearing on behalf of the. We should recall that order.
Yes, Your Lordship.
Huh?
Yes, Your Lordship. The
Why?
matter, Your Lordship, as per the instruction received, the matter is related to whether petitioner would have got salary in the SO or not is the cross of the matter, Your Lordship.
Make a question.
File
Your Lordship.
File an IA for recall of the order.
because upon your submission, we have confined our order to that extent. You confined your order on that date. So now if you want to open up, then you have to recall.
Your Lordship, will file an IA.
To file as per your instructions.
Requested on behalf of learned counsel appearing on behalf of the petitioner states that without instructions from the petitioner, he had made his submission on the last occasion when the matter was taken up on 29/2/2024, that the petitioners should confine his submission. That he should confine his submission to the petitioner's claim of salary from the date he was relieved from arbitration tribunal till he attained the age of superannuation on 30/9/2013 and the post-retirement benefits. So he wants to file an application seeking recall of the order dated 29/2/2024. Stop this matter on 8 weeks.
Item 36.
Please, Your Lordship.
Please, Your Lordships. Lordships, remember, this is the matter where it's 33 to application. While passing the order, he had interfered, the presiding officer had interfered with the quantum of punishment. So I had explained before, Lordships, what is the gamut of adjudicatory powers of the court, or so far as the labor court is concerned, or the industrial tribunal under section 33(2)(b). So your Lordships wanted that if any like financial benefit or anything can be granted. So I had had a discussion with up to even the director level, my lord. Unfortunately, what had happened after that, because this action they took was on 1st of March 2011. But on 3rd of March, their chief executive officer was burnt alive by the employees, and part of the crowd, one of them was directly involved and the others were part of the crowd of about 20 persons. So the criminal cases are pending. So they said that if we do this as a gesture, also it may, because they are still absconding, many of them. So that will affect their entire industrial situation, my lord, there at the place. So that was the most unfortunate part, that these people were very much involved in that incident, and which happened on 3rd of March. And the termination order was passed on 1st of March. So that is the Lord situation, ground level situation, which Lord, otherwise they said that had been any other person, those who would have been involved, then the things would have been different. We would have definitely considered some financial benefit for them. But since they were directly involved in burning alive, my lord, he was burned in a car. He was caught, his car was stopped, he was garoed, and he was burnt alive while sitting inside the car, their chief executive officer at that point of time, which became an issue also at that point of time in 2011. Lord Justice Raman might recall that this industry was earlier known as GKW Palmex.
Now it is Palmex Steel.
Earlier, then Palmex still, then now it is Graphite India Limited. They have taken over. Because that remained closed for a long time after that thing. So the management at the top level, they had a sharing, brought in private equities, and then they integrated with Graphite India Limited.
I got confused at page 14.
The GKW Limited.
Graphite India is stuck up.
And on the date of termination, it was GKW Palmex Limited. So this was when it was filed. No, it was Graphite India when this was Palmex Steel Division. It was.
fact, my lord, the person who represented the company in the proceeding, he was the person who was burnt, which is in the cause title of the award at page 15. The DGM operations come factory manager. He was the head of the factory at that point of time.
This application was filed under section 32.
33 to B.
33 to B.
Yes.
What is there? What is that?
Yes, if your lordship should have the Industrial Disputes Act, I'll just read out and Lord explain what is the concept of 33 to B.
Yes, please.
Lord, 33 says condition of service, etc., to remain unchanged under certain circumstances during pendency of proceedings. That is pendency of proceedings before any labor authority, if a conciliation proceeding is continuing, or if the matter has culminated in a reference or any dispute is pending, then before either the industrial tribunal or the labor court. So if there is a pendency of a proceeding during that time, if a person who is directly connected with the dispute, his service condition cannot be changed without prior approval of that particular court. But if it is not connected with the dispute, that is 33(2)(b), then post facto approval is to be taken. I have to take the action, then make an application simultaneously for the post facto approval of the action taken by the management, which changes the service condition of the particular employee. So I'll just read out before your lordships. 33(1), during the pendency of any conciliation proceeding before a conciliation officer or
So this has been disapproved.
No, it has been approved, but he said that you now don't, like, the termination is not commensurate, make a lesser punishment.
Right.
So on that account, it is disapproved, but so far as the fairness of the domestic inquiry is concerned, it has been held that it has been done, Lord, fairly and properly.
The order appears to be just.
My lord?
The order passed by him appear to be just.
No, my lord, under 33(2)(b), he cannot tinker or he cannot do anything so far as the quantum of punishment is concerned. That is the law settled by the Honorable Apex Court also. Under the section 11A, which is when an award or a reference is made under section 10(1), then he can, my lord, have a say so far as the quantum of punishment.
There's a question of quantum of punishment. He doesn't say anything. He just say that you cannot discharge or dismiss.
No, my lord. Which one? I'm sorry.
You are challenging which order?
Your lordships may see it starts from page 15. Your lordships may come to page 18 of the brief. Your lordships are holding, my lord, 22006 of 2014, if that is the brief.
Page 16, yes.
Page 16. Para 6, so far as the legality of the punishment, in the previous para, my lord, previous page, he says that I have no hesitation to hold that the domestic inquiry conducted by the management was fair and proper.
So please come to paragraph 7.
Yes, my lord. The para 7 is, my lord. I'll just, prior to that, my lord, I'll just read out, if your lordships permits me, para 6. Then para 7, your lordships will make the connection with it. I find the allegation against the workman is that on so-and-so amount, on date at 10 p.m., he did not perform the duties along with other workmen under protest for an alleged assault on a regular workman. The workman also participated in a call for stoppage of work by other workmen from so-and-so, which resulted in loss of production of the company. The opposite party workman did not initiate any strike, nor did he call for the stoppage of work, but he only responded to the call for refusal of work on a particular cause. He has not directly caused any loss to the company, and therefore the punishment of dismissal from service of the OP workman, in my considered opinion, was not commensurate to the acts alleged against him.
Rightly. And therefore,
And
therefore he has declined
that he cannot do. My respectful submission is under section 33(2)(b), it's a very technical section, my lord. There are certain parameters which has to be followed while 33(2) application is being made. So he has to make an inquiry which is of a summary nature. He cannot go inside the evidence or reappreciate.
No,
which
no,
my lord.
he has not
And
done
also, so
anything.
far as the punishment is concerned, on the last occasion, I had, my lord, placed before your lordships a judgment of the Honorable Apex Court, 2019-18 SCC. I think that would be there on record.
2019.
2019, volume 18 SCC, page 47.
Is there. What is the party name?
My lord, that is John D'Souza versus Karnataka State Road Transport Corporation.
Yes.
If your lordships would come to, my lord, para 17, which is the, my lord, running page would be page 10 of that judgment.
Yes.
Para 17, my lord, deals with section 11. Then para 18, section 11A of the Act unequivocally empowers the labor court tribunals and national tribunals to set aside the order of discharge or dismissal of a workman and direct his reinstatement on such terms and conditions as it thinks fit, or to award any lesser punishment in lieu of such discharge or dismissal, provided that the labor court or the tribunal, as the case may be, satisfied that the order of discharge dismissal was not justified. So this power is under section 11A. Now I take your lordships to if your lordships would come to para 21.
Yes.
The legislature has thus provided a self-contained mechanism under section 10, read with section 11(3) and 11A of the Act, for adjudication of an industrial dispute stemming out of an order of discharge or dismissal of a workman. Having done so, it can be safely inferred that neither the legislature intended nor there was any legal necessity to set up a parallel remedy under the same statute for adjudication of the same industrial dispute by the labor court, forum of labor court or tribunal via section 33(2)(b) of the Act. To say it differently, section 33(2)(b) has been inserted for a purpose other than that for which section 10(1)(c) and (d) have been enacted. Section 32(b) thus is neither meant for nor does it endanger an overlapping procedure to adjudicate the legality, propriety, justifiability, or otherwise sustainability of a punitive action taken against a workman. Having held so, it should not take long to trace out the legislative object behind incorporation of section 33, including subsection 2 thereof. The caption of section 33 itself sufficiently hints out that the primary object behind this provision is to prevent adverse alteration in the condition of service of a workman when conciliation or other proceedings in respect of an industrial dispute to which such workman is also concerned are pending before a conciliation officer, board, arbitrator, labor court, or tribunal. The legislature, through section 33(1)(a) and (b), has purposefully prevented the discharge, dismissal, or any other punitive action against workmen concerned during the pendency of proceeding before the arbitrator, labor court, or tribunal, even on the basis of proven misconduct, save with the express permission or approval of the authority before which the proceeding is pending. Subsection 2 of 33 draws its color from subsection 1 and has to be read in conjunction thereto. Subsection 2, in fact, dilutes the rigors of subsection 1 to the extent that it enables the employer to discharge, dismiss, or otherwise punish a workman for a proved misconduct not connected with the pending dispute, in accordance with standing orders applicable to the workman or in absence thereof as per terms of contract, provided that such workman has been paid 1 month wages while passing such order and before moving application before the authority concerned for approval of the action. In other words, the authority concerned, that is board, tribunal, or the labor court, has to satisfy while considering the employer's application that the misconduct on the basis of which punitive action has been taken is not the matter sub judice before it.
So this was not the matter in respect to.
Section 10(1). This is under 33(2)(b).
No, this is under 33(2)(b). 33(2)(b) states that for any misconduct
Not connected with the dispute.
Not connected.
Not connected with
It
the
was
dispute.
not connected.
It was
with
not
the
connected.
dispute. And then you cannot discharge or punish, whether by dismissal or otherwise, that
Without
workman. Without
paying 1 month notice. No, not without approval. 33(2) says I have to make a application for post facto approval. One is prior approval. My lord, there lies the difference between 33(1) and 2. One is a person who is connected with the dispute.
Yes.
Then I have to take prior permission.
Right.
33(2) says if he is not connected with the dispute, then I can take the action, but then I have to make a simultaneous application for approval of that action. So which is a post facto approval.
Yes.
So here I made the application under 33(2)(b). And the parameters of section 33(2)(b) says that if I read out that section again.
See, the word shall comes after. Shall would surely come after, because it says provided that no workman shall be discharged or dismissed.
Yes.
So this will be.
No, my lord, then
this
it
will
has
be
to be read,
subsequent.
my lord, read in toto, if your lordships, I'll just take another, my lord, 33(2)(b). During pendency of any such proceeding in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to the workman concerned in such dispute, or where there are no such standing orders in accordance with the terms of the contract, whether express implied between him and the workman, alter in regard to any matter not connected with the dispute, the condition of service applicable to that workman immediately before the commencement of such proceeding, or for any misconduct not connected with the dispute, or discharge or punish, whether by dismissal or otherwise, that workman, provided that such workman shall not be discharged, dismissed unless he has been paid wages.
So this is future tense.
And an application has been made.
This is again.
My lord, not that the approval is taken.
No.
My lord, one is.
What I would, speaking for myself,
yes,
this shall be discharged. This will come later. After this amount is paid, wages for 1 month, and application is made. So unless you do.
Yes, simultaneously. It has to be all simultaneous.
Unless you do these two things, you cannot discharge or dismiss.
I have done that. 33, making the application I have done. But the approval is not required at the time of discharge or dismissal. That is, my lord, the judgment. I'll, my lord, explain, my lord, 33(2)(b). No, my lord, there are umpteen number of judgments, my lord. I'll show post facto, pre facto, the 33(1) and 33(2)(b). My lord, because the 33(1) is, if he is directly connected, then expression, permission.
The expression says that nothing shall be done.
Yes, my lord.
Nothing shall be done if this is done. Then that shall be done after that is done.
Yes, my lord, that is done is my action. My part is to make an application,
yes,
to seek an approval.
Yes.
Not that the approval has to come before I effect it.
No,
Lord,
before that is made effective, the order of discharge or dismissal is made effective. There has to be an approval. There has to be.
That is 33(1), my lord, not 33.
No, 33(2)(b).
No, my lord, not 2b.
Huh?
I'll, my lord, I'll just, my lord, that's why, my lord, I was showing that judgment. If your lordship should come back to that judgment.
In fact, we will take up the matter tomorrow because we have to hear one urgent matter.
All right. Tomorrow, I think tomorrow your lordships have already fixed that other matter.
This will hardly take, we have already heard you, we'll just see few decisions.
My lord, that distinction I'll make, my lord, before your lordship.
Please.
With the judgments also as well as. My lord, the interim audit, my lord, is there. So your lordship can simply say it.
Tomorrow.
I will
make mention, my lord, small submission is there. The urgent matter is there, item number 38, my lord. Let me.
What is this about?
Tomorrow.
Tomorrow it will be there.
Tomorrow it will be there.
Tomorrow it will be there, and tomorrow, if it is not likely to be taken up, then you can make a mention in the first half. We shall try that your. Yes.
My lord, here in this case, the present appellant is inside custody since 4/4/2014, my lord. From the very same day of the occurrence.
Yes, what is the offense?
My lord, the offense is 20B2C of NDPS Act, my lord. And he is convicted for 10 years and to pay fine of rupees 1 lakh, and in default, by not paying, in default to further arrive for 1 year, my lord.
Okay.
Have you filed any application?
My lord, for stay realization of fine, there is application of 1/444 of 2015, which is there is a stay, and one for bail.
Where is the application for bail?
Well-
22. IA number 1294.
No, madam, for bail application, there is 144 of 2.
Have you paid the fine?
No, madam.
And what is the other case?
My lord, in the other case, there is the co-accused. As per the instruction, he is known.
So what do you want in this case, in this appeal?
My lord, the person is already undergone for more than 10 years, which
Then?
is the conviction. And in the default for the fine amount, he is inside the custody, but which is stayed by this court.
Fine was stayed.
My lord, 1/444 of 15. The order dated, my lord, I am saying that. My lord, 12/11/2015, my lord. By the order dated 12/11/2015.
First appeal, IA number 1294.
My lord, I number 1/444 of 2015 for stay.
No, no,
Here made the one thing. There are two appeals. One of the one appellant is already dead.
all right, that
The
shall await.
other appellant, he should have been released by now because he has already undergone more than 10 years.
So she says he has not been released.
Last time not, I am saying because of the fine remark, because in report 1 year RI. So you will also take it up on Friday after the lunch. We'll see that he is released because it seems that he should not be confined to this jail after this period is already over. Yeah, the fine amount.
If your lordship sets aside the stay of realization of further matter, then only he can pay the fine and he can.
No, that is state.
So that is the reason why he is not able to pay the fine.
He should not pay,
Yes.
but he will have to be released.
He has to be.
The fine has been a state. He has served the sentence. Then he will have to be released.
Yes, sir. So that's the same lordship day after tomorrow. Then also I think he has overstayed, and that period can be calculated for fine, or he may not be required to pay the fine also. I think so. So what do you say, we have 1 year RI, and he has ordered 10 years, but there must be some remission within 10 years. He must have remission for more than 6 months. Or else you also make release also. There is no problem. We have no objection for his release because we are all
Appellant stands convicted of the offense punishable under sections 20 bracketed B bracketed 2 bracketed C of the NDPS Act by a judgment dated 25/8/2015, passed by the learned special judge Adgar. Stop. The learned trial court has sentenced him to undergo imprisonment for a term of rigorous imprisonment for a term of 10 years and fine of ₹1 lakh, in default of which, to undergo RI for further 1 year. Stop. Next. By an order of this court dated
12/11/2000.
what is that? 15?
12/11/2015, my lord.
12?
11.
12/11/2015. The realization of fine amount has been directed to be stayed. Stop. Learned counsel appearing on behalf of the appellant has submitted that the appellant is in custody in connection with the said criminal case since 4/4/2014 and has already served the sentence. Stop. Next. In such view of the matter, let the appellant be released forthwith from which jail? Which jail?
Athagad Sessions Judge. Special Judge Athagad.
Released forthwith from jail custody. IA number 1294. This application stands disposed of accordingly. This application was filed for bail.
My lord.
उसको कर देना
पहले आइए number
1444
1294 of 2022.
1442, my lord. Okay.
This application has been filed for suspension of sentence and the appellant's release on bail during the pendency of the present appeal. तब लिखोगे the appellant stands convicted. Okay. See, in two bracketed A bracketed CC, this is the case number.
My lord.
2A CC number 08 of 2014. Which are bracketed arising out of PR number 2/14-15. Bracket closed. Yes, second appeal. It has been stated by learned counsel for the appellant that the appellant died during the pendency of this appeal. So the appeal abates and stands disposed of accordingly. दूसरे वाले
After we mentioned the court minutes, special judge at God.
A special judge,
At